of Public Prosecutions Uganda and Vice President of Eaap and our host, the Director of Public Prosecutions of Tanzania, who is also the President of Eaap, the Director of Public Prosecutions Kenya, the Secretary General of the East African Association of Prosecutors, the Prosecutor General of Burundi, the Prosecutor General of the Democratic Republic of Congo, the Director of Public Prosecutions South Sudan, who is the General Counsel of the East African Association of Prosecutors, the Director of Public Prosecutions Zambia, Director of Public Prosecutions Malawi, Head of the Federal Public Prosecutors Administration Council of Ethiopia, the representative of the Prosecutor General of Rwanda, our development partners present, fellow prosecutors, all distinguished dignitaries in your respective capacities, members of the press, good morning. You're all welcome to today's session. This session is going to be chaired by our Attorney General of Uganda, the Honorable Chiriowa Chiwanuka, who is present. Honorable Attorney General, you're welcome. This is the 10th Annual General Meeting and Conference of the East Africa Association of Prosecutors. This general meeting is held annually and on a rotational basis, and this year, Uganda is hosting. Sir, in the audience, you have Attorney Generals, Directors of Public Prosecutions, and other heads of delegations from different member countries. This is an association of prosecuting agencies from 11 countries. In the audience, you also have prosecutors who have accompanied the heads of their delegations. This morning, the session, sir, is intended to share experiences, efforts, and plans we have in mutual legal assistance and extradition in criminal matters. Sir, I hereby hand over the microphone to take up the session. Mine is written, but let me get a quick one.
Good morning, delegates. I hope you slept well and had breakfast. I can see the faces are not looking like last evening. The Honorable Attorney General, we were here yesterday until almost midnight. And the whole room was asleep. It was a difficult task for the chair of the meeting. That was DPP Aji of Kenya. And the Honorable Attorney General, you're most welcome to this conference. Mr. Biansi, George William has already laid out the protocol. So before you, we have the Directors of Public Prosecutions and Prosecutor Generals and Attorney Generals of 12 countries in the region. And we have been here since Saturday. And we have had a very good conversation on around the areas of mutual legal assistance. Among us, we have countries where they already have a law on mutual legal assistance, and it's a good thing for us to have candid conversations on that. And now we go forward, because even without the law, we still need to work together because of the kind of crimes that we are faced with in the region and beyond. So, the Honorable Attorney General, we have the theme for the conference is really focusing on practical ways of how we are going to handle cases of women and children, because during the lockdown for the last 2 years, we had a spike of cases involving women and children. So we thought the theme for this conference should focus on that. The hosting of the conference and the AGM is rotational, and this time we are the host. So, and we are pleased to announce that we have full house. All members stand up. We have the DPPs and Attorney Generals and Prosecutor Generals, and they have come with delegations of between 3 and 7. So we are very happy that we are hosting them, and we shall be here until Thursday. That's when they depart. So the Honorable Attorney General, I want to leave you with to handle the session and make your remarks, and then invite the participants of this session. But you're most welcome, the Honorable Attorney General, for accepting to come and be with us despite your busy schedule. You're most welcome.
Yes, good morning, everyone. You know, I've been told that you are here until midnight last night, and we know the cover of darkness is the best place to commit crime. I hope the DPP of Uganda will not be investigating any DPP. But it is also very important what you're saying is that we have taken the task that has been bestowed upon you seriously. And the beauty about a session such as this one is we are all in a room speaking the same language, which is the law. You know, it is a session where you have a discussion and you understand each other at the same level. So you're most welcome to Uganda. We hope you stay here longer than you had anticipated, so you can go out and see a little bit outside crime and enjoy Uganda and its beauty before you head back home. Ladies and gentlemen, the protocols have been set out, but I would like to specifically recognize the presence of the Attorney General of Somalia and the Deputy Attorney General of Mozambique. And then I'd like to recognize the presence of all the directors of public prosecution from the different fraternal countries that are here in Uganda. You're all welcome in your different capacities. We welcome you all. My task this morning, as I've been advised, was just to moderate a session on harnessing international cooperation to combat transnational crime in East Africa and beyond. This theme is actually very important because, as you all know now, the world is a global village. What happens in one country invariably affects another country, and especially where your neighbors. So over the years, crime has evolved, and has evolved greatly, and the Commission of Crime is now organized, and it's really transnational. It spans beyond borders. We no longer have boundaries because I can communicate with someone in Mozambique, have a transaction with someone in Mozambique without actually meeting them, without actually stepping out of my room. While I was in private practice, I would represent clients that I've never seen, never met, and for a couple of years you're carrying out transactions for them and you actually never met them physically. So with technology coming in place, your task is even greater because an offense can be committed in your jurisdiction thousands of miles away from where the perpetrator is. Obviously, you're going to seriously think about the definition of crime and how crime evolves, and therefore your laws need to be evolving as fast as technology. Now, all of you here know how difficult it is to process a piece of legislation. But you all know how quick and easy it is for technology to evolve, for the world to evolve. So you have a duty and a responsibility to ensure that you're moving faster than technology. I don't know how that is going to happen, but we are praying for you. Because as technology, as society evolves, even crime evolves. Methods of committing crimes also evolve. Now, without a law, I think in this room it's the best place where you know that you cannot be charged with an offense that doesn't exist on a statute book. So as time changes, as circumstances change, you need to evolve with those times. Different regional, international, and even local, national legal frameworks have been put in place to facilitate cooperation between states, between countries for mutual legal assistance and extradition. Within East Africa, all East African member states are members of the ICGLR, which places down the protocols under which we cooperate. Outside East Africa, we have Eaap. In the EU, we have the EU Mutual Legal Assistance. In the UN, we have the UNCTAD, United Nations Convention Against Transnational Organized Crime. And with all these and their supplementing protocols, the legal obligations on member states are clearly set out. But why is it still a challenge? That's the question we need to ask ourselves in this session this morning. There are many other protocols which I may not mention, which I may not have stated here. But despite all these instruments, countries continue to face this challenge in executing requests for mutual legal assistance. And this is perhaps because of the peculiar circumstances that obtain in the different states. And therefore, the session you're having this morning is really timely. In my office today, I receive mutual legal assistance requests from different jurisdictions. And I have to always look out and try to understand what is the law in that jurisdiction, how does it relate to our law, how does it relate to the international space. Is the law in Kenya? Is the law in Mozambique? Is the law in Somalia? Is it an offense in Uganda? Maybe it is time we start thinking about all these things and try to come up with a uniform structure that we can use, and that is what I think we'll be dealing with this morning. So the primary focus of this session will be to explore approaches that will allow us to improve our mutual legal assistance requests and how to deal with the phenomenon of transnational crime. Ladies and gentlemen, I think we all know that transnational crime is some of the most difficult crime to deal with because it's extremely organized. It's not petty, it's extremely organized. So in order to break this down, we need to sit down and work together to try and find a solution to this problem. Mine is to moderate, and I'm going to request that we go through this session. Let us share. Let us put out our experiences. Let us share our challenges. Let us try and find solutions together on how we can deal with this crime. What I can tell you, colleagues, and which you must all know, is that there is no way a crime committed in Uganda will not affect you. And we know that there is no way crime committed outside Uganda in our neighbors will not affect us. So we are all in this together. And as we sit here together today, let's try and look at what we can do to ensure that we deal with this. So I am advised that each participant will be allowed 8 minutes, and all discussants will present, and then I'll open the floor to the discussion of the session. We shall use the schedule as set out in your program, and therefore I call upon the Republic of Kenya to take the floor first, and then I will guide you as we get along. I thank you very much for listening to me. I wish you great deliberations this morning, and may God help us as we continue to protect our people. I say all this for God and my country. Thank you.
Thank you very much. I'm going to make a brief presentation on the experience of Kenya in international cooperation. I request the secretariats to screen the presentation. Yes, so this is the presentation, and the objective, of course, is to present on the efforts and plans by Kenya to enhance international cooperation. I'm also going to share with you the challenges we are facing and some of the best practices. So the legal framework in Kenya is primarily based on the Constitution, which provides that any treaty or convention ratified by Kenya shall form part of the laws of Kenya. This gives the Office of the DPP a proper legal basis to make any request for mutual legal assistance or extradition. Of course, this does not mean that Kenya is a monist state. Kenya is a dualist state. Each convention has to go through the ratification process. We have laws on extradition. We have laws on mutual legal assistance. We have laws on the protection of witnesses. All the laws, the main features are the mode of making a request for mutual legal assistance or executing a request for mutual legal assistance, or the mode of initiating extradition proceedings in court pursuant to this request received from requesting states. We also have laws which domesticate particular universal instruments like on prevention of terrorism, organized crime, international crimes, narcotics, counter-trafficking in persons, and torture. And the main features of all these is that they provide for extraditable offenses, the mode of initiating requests. They also criminalize particular offenses under the particular conventions. In terms of the theme of EAP's this year's AGM, these are some of the laws in place in Kenya: counter-trafficking in persons, prevention of torture, all these. And again, the main features, all the offenses under this act are extraditable offenses. The acts also provide for mutual legal assistance and extradition under the specific laws. We also have a commission on gender and equality, which again is relevant to the theme of today's AGM. In terms of mutual legal assistance, as I said, we have an act of parliament, and one of the best provision in that act is that Kenya may render legal assistance in the absence of a treaty. This is unlike in extradition, which is treaty-based. But we find this quite useful to us because we can render mutual legal assistance without a treaty. The Act provides for a central authority, that is the Office of the Attorney General. And I must stress here that the central authority, that is the Attorney General, is only for purposes of mutual legal assistance and not extradition. Extradition is processed through diplomatic channels. It makes provision for competent authorities, including prosecuting and investigating agencies. So the Office of the DPP is a competent authority. We can make and execute requests for mutual legal assistance. The other provision is the types of requests that we can render and the mode of making the request, grounds for refusal, the contents of a request, and the like. These laws, before I go further, these laws are all available online. You can get these laws online and know the provisions before making any request to Kenya, so that your request may be considered. On extradition, we have two pieces of legislation, one for Commonwealth and another one for all other countries. The laws make provision for which offenses are extraditable, the mode of initiating proceedings for extradition in court, the threshold, which is a probable cause, that is as opposed to beyond reasonable doubt, the provisions for restrictions on dual criminality, abuse of human rights, double jeopardy, and speciality. That is, a fugitive returned to Kenya can only be prosecuted for an offense which is specified in the request for mutual legal assistance. It also makes provision for admissibility of evidence. We have encountered numerous challenges in the execution of requests for mutual legal assistance and extradition. We have language requirements. Sometimes we even receive requests in languages which our officers might not understand. And when we are making requests out of the country, there is the cost of translating all the documents, which again is very high. Refusal or outright failure to render requests by countries, lack of a legal basis. For instance, mainly in extradition, we have not entered into treaties with some of the countries, and they are making requests to us. So what happens is that if we go to court, this issue will be raised by the fugitive, and the likelihood of the request being granted are slim. Dual criminality requirements, extradition of nationals. Most countries do not extradite their nationals. But Kenya, the acts state that we have an obligation to extradite whether or not it's a national of Kenya. Protracted extradition proceedings in requested state. Currently, we have a request which is pending in a European country. It has taken since 2008, and the fugitive has never been returned to Kenya. Capacity of judicial officer, of judicial and counsel. This is not the usual crimes or duties they perform on a daily basis. They are prosecutors. They have expertise in the prosecution of other offenses, frauds, stealing, and the like. But international cooperation is not what they do on a day-to-day basis. So the capacity is again wanting. We also have received requests which are not made in good faith by some countries, maybe to release the subjects. So what are some of the recommendations as I conclude? Increased international cooperation. It is encouraged that countries do negotiate bilateral treaties for extradition and mutual legal assistance. This helps the countries set out the mode of executing, making requests for mutual legal assistance, the contents, and even thrash out some of the issues raising like dual criminality, extradition of nationals, language, and the like. Again, capacity building, enriching our officers, whether they are prosecutors or whether they're investigating agencies, with the requisite knowledge to be able to either make requests or execute requests. I can give an example of a prosecutor in Kenya who was in charge of our station in Busia. Busia is our border town with Uganda. He made a request directly to the DPP of Uganda. I think that was 2016 or 2015. He made a request, and the DPP of Uganda, Mr. Chebita, called the then DPP and asked him, who is this making a request to me? The DPP told me, tell that prosecutor there is only one DPP in Kenya, so and so. So you can see how the capacity of prosecutors or international cooperation affects the way they do their work. A background checks is very important. It's important to research on the laws and the legal requirements of the country you are making a request to ensure that your request is considered. Informal networks, starting with the Eaap, Eaap, Arinea, and multiple, what I can say is that multiple networks mean multiple assistance. You can always informally, through informal communication, call your colleague in another jurisdiction, get the information. Informal communication through phone calls and the like. Oops. Law reform. As the legal practitioners for international cooperation, it's us who knows where the shoe pinches. So we have to be in the forefront in legal reforms to ensure that the laws conform to what we want to practice in the field of international cooperation. So we should be in the forefront, be proactively involved in law reforms through, of course, the relevant channels in our respective jurisdictions to ensure that the laws are amended. Tackling dual criminality, different legal reforms. It's important to enter into bilateral treaties to tackle this. Extradition of nationals, again, we should have bilateral treaties to provide for the principle of either you extradite or you prosecute. Focal point persons, very important, who should be trained. They should be available 24/7. Admission of evidence, Translation of documents, very costly at times. And one of the ways you can go this is through the online translation mode. Then after that, you can go for certification because you cannot send the document before it is certified to be a true translation. And for the funding, non-state actors can come in handy. Enrich the EAP website with all the laws of the member countries, the requirements, expert articles of international cooperation for use by our prosecutors, information sharing on new trades in transnational or organized crimes, very important. Concurrent requests, we should have ways of tackling concurrent requests because at times we receive a request for the same fugitive or for the same information or evidence from different jurisdictions. We need to have bilateral treaties to tackle this. How do you tackle this? But the objective to be justice to be served expeditiously. Sharing of information. I think I've talked about this. Domestication of international instruments, very important, of course, in accordance with the relevant legal provisions of each country. Memorandum of understanding as a country, Kenya, and even as an office, the office of the DPP, we have entered into mutual legal assistance with different offices of the DPP within Africa and outside Africa, and with some under other MOUs with some non-state actors. Our guidelines, I think the next slide is on guidelines. It's important that we have guidelines in each of the respective countries on handling international cooperation matters. So these are some of the recommendations and best practices which countries may embrace to ensure that mutual legal assistance and extradition is granted as and when required. Again, guidelines. It's important to have guidelines for our prosecutors. As I said, this is not their day-to-day work. It is important that they know how to go about it. And lastly, tools, training manuals. All these are very important for our prosecutors. Draft chassis, compendiums, points to prove, and the like. Thank you very much. That was my short presentation.
Thank you very much. When a person comes to speak, you need to introduce yourself. But I'm going to introduce you, Honorable Mr. Nuruddin. I've given you the job because you said there's only one DPP.
Yeah.
So you are the only DPP in Kenya.
No.
Okay. Because you told us there's only one DPP, but you need to introduce us because when you speak about informal arrangements, we need to know each other. So when you're speaking to this person, you can put a name to the face. So that next time you make a call to Uganda, we know the person we are doing what we are dealing with. So please introduce yourself. So since you're not the only, okay.
Apologies, Attorney General of the Republic of Uganda. My name is Victor Mule, and I'm not the DPP of Kenya. I'm the Deputy DPP. And I'm in charge of a department called County Affairs and Prosecution Services, and I'm sorry for that. Thank you.
Thank you very much. So now you know he's not Mr. Nuruddin Haji. So, because he said there was only one DPP, but thank you very much for your presentation. I think the challenges you have had, and these are things that we need to look at. But he mentioned something very important, which I want us, as we prepare for Mozambique to come in, the issue of building capacity. Building capacity so we can understand the legislation in the different jurisdictions and also using the correct channels to communicate. So I'll request the representative from Mozambique to come up and make their remarks.
Good morning, ladies and gentlemen. His Excellency, the President of Eaap, and His Excellency, the Vice President, and also the Secretary General, His Excellency Nuruddin Haji. Good morning, everyone. And on behalf of the Attorney General of Mozambique, I would like to take this opportunity to thank you all, and especially thank you, Honorable Lady Jan Obodo, for the grateful reception and organization, and also to give us the opportunity to share our experience on this topic. To express myself better, I will talk in Portuguese. I'm really sorry. So our barriers of language will start now. So my presentation will follow the structure. It's there. I'm sure they are translating correctly. Dizer que Moçambique confronta-se com o crime organizado e transnacional, como nos demais países que estão aqui presentes e outros países da África, designadamente o tráfico de pessoas, mulheres e crianças, o branqueamento de capitais, o tráfico de drogas e o terrorismo e o seu financiamento, bem outros tipos legais de crime que são bem conhecidos e que todos nós vivenciamos. Os principais atores no combate ao crime organizado e transnacional instalados em Moçambique são essencialmente a Polícia da República de Moçambique, os Serviços de Investigação, o Serviço Nacional de Investigação Criminal, os procuradores, portanto, o Ministério Público, os Serviços de Inteligência e Investigação e, com certeza, os tribunais. As medidas para o reforço da cooperação no combate ao crime organizado e transnacional que o governo de Moçambique adotou. O fenômeno da globalização e o desenvolvimento tecnológico permitiram uma maior circulação de pessoas e bens no país e também permitiram o desenvolvimento de uma criminalidade mais evoluída e transfronteiriça. E a natureza transfronteiriça que o crime vem assumindo impõe aos Estados a necessidade de cooperar e buscar cooperação. Nesta perspectiva, Moçambique adotou medidas internas, legislativas, bem como medidas legislativas a nível internacional. Foi adotada a Lei número 21/2019, de 11 de novembro, que define os princípios e os procedimentos de cooperação jurídica e judiciária internacional em matéria penal. Esta lei define a extradição, a transmissão de processos penais entre os países, a execução de sentenças penais, a transferência de pessoas condenadas a penas e medidas preventivas da liberdade, a vigilância de pessoas condenadas ou em liberdade condicional e ainda o auxílio judiciário mútuo. Esta lei designa também a Procuradoria-Geral da República como autoridade central, competente para tramitar os pedidos de cooperação jurídica e judiciária internacional em matéria penal. Moçambique aprovou ainda a Lei número 13/2020, de 23 de dezembro, que regula a perda alargada de bens e recuperação de ativos. Do ponto de vista de ações não propriamente legislativas, a Procuradoria-Geral da República criou o Gabinete Central de Recuperação de Ativos e o Gabinete Central de Combate à Criminalidade Organizada e Transnacional. A nível do direito internacional, Moçambique ratificou a Convenção das Nações Unidas contra o Crime Organizado e Transnacional, bem como os seus protocolos, através da Resolução número 86/2002, de 11 de dezembro. Além desta convenção, Moçambique ratificou a Convenção contra o Tráfico de Pessoas, a Convenção contra o Combate à Corrupção, a Convenção sobre o Combate ao Terrorismo e seu financiamento, que, de alguma forma, estas convenções fazem o apelo à cooperação internacional para o reforço do combate ao crime organizado. No âmbito do auxílio mútuo legal, em 2022, Moçambique enviou 34 pedidos de auxílio mútuo legal, dos quais apenas 4 foram respondidos. E Moçambique recebeu 19 pedidos de auxílio mútuo legal e respondeu a 16. Portanto, apenas 3 é que ainda estão por ser respondidos. No que se refere à extradição, a extradição é a forma de cooperação mais complexa e que mais tempo leva devido às formalidades que deve seguir. Temos a autoridade requerente, que remete ao Ministério dos Negócios Estrangeiros e Cooperação. O Ministério dos Negócios Estrangeiros e Cooperação, por sua vez, remete à autoridade central, depois ao Ministério da Justiça, dependendo, e há que remetem diretamente ao Ministério Público ou ainda ao Tribunal Supremo. E depois é que se verifica a entrega do extraditando. Para obviar a esta morosidade que o formalismo da extradição se presta, Moçambique dá uma prevalência, digamos assim, à existência de acordos entre as partes. Portanto, acordos regionais ou acordos bilaterais que facilitam a extradição. Portanto, nós temos como exemplos acordos de extradição entre o governo de Moçambique e o governo do Ruanda. Também, em relação à extradição, dizer que, dos poucos pedidos recebidos por Moçambique, Moçambique adota uma estratégia para a entrega rápida dos extraditandos. A título de exemplo, nós trazemos aqui o caso do pedido de extradição de um cidadão procurado pelas autoridades judiciárias brasileiras por tráfico de drogas, porque o processo de extradição, a formalidade da extradição iria levar muito tempo, seguiu-se um processo administrativo de expulsão e, assim, mais facilmente se satisfez o pedido das autoridades brasileiras. Na falta de acordos de extradição, Moçambique pauta pela observância do princípio da reciprocidade. Portanto, o tratamento que o país dá aos pedidos de Moçambique é o que Moçambique também fará em relação a esse país. Em todo este processo, verificamos que existem desafios e trazemos aqui esses desafios e as possíveis soluções. Em termos de desafios, o primeiro que se nos apresenta é a deficiente comunicação. Quando solicitamos um pedido de assistência mútua legal, muitas vezes leva muito tempo para termos apenas uma resposta que diga que esse pedido foi recebido, que esse pedido chegou à pessoa a quem nós solicitamos. Portanto, há aqui um problema sério de comunicação entre as partes. O outro desafio que se nos apresenta é a barreira da língua. Portanto, como nós todos sabemos, Moçambique está localizado numa posição tal que todos os países que são à sua volta são de expressão inglesa. E Moçambique é o único país de expressão portuguesa. E então a língua também aparece aqui como uma barreira, de certa forma. Por outro lado, nós temos a problemática dos diferentes sistemas jurídicos. Portanto, Moçambique é de uma raiz romano-germânica, é de um sistema cuja raiz é romano-germânica, enquanto que os países que estão à sua volta são anglo-saxônicos e seguem o sistema da common law. Esta diferença de sistemas traz consigo também diferenças quanto aos procedimentos, diferenças quanto à tramitação, o que também contribui para uma certa morosidade e dificuldade na cooperação jurídico-legal. Outro desafio prende-se com o tempo da tramitação e execução dos pedidos de cooperação, que de alguma forma está relacionado com a comunicação deficiente, com as barreiras da língua e mesmo dos sistemas jurídicos diferenciados. Um aspecto também relevante que constitui desafio é a fraca articulação informal nas redes de cooperação. Portanto, apesar de termos nos aproximado cada vez mais, os Estados terem se aproximado cada vez mais, as procuradorias terem se aproximado cada vez mais, mantém-se um certo rigor, um certo formalismo e há aqui uma necessidade de uma maior articulação informal. Como soluções, pensamos que para uma melhor comunicação, Moçambique privilegia, através da autoridade central, a acusação de recepção dos pedidos da assistência mútua legal e a atualização periódica sobre o ponto de situação da execução desse pedido. Portanto, por uma questão de celeridade, pelo menos assim que o pedido entra, Moçambique notifica o país para informá-lo que recebeu essa solicitação. Portanto, acusar a recepção e depois fazer todos os esforços no sentido de dar resposta em tempo útil. E outro aspecto que também que ajuda, de alguma maneira, a solucionar estas barreiras é a assinatura de memorandos de entendimento entre os ministérios públicos de vários países africanos. Portanto, Moçambique vem ratificando memorandos de entendimento com países com vista a reduzir estas dificuldades de comunicação e de resposta. Em termos de perspectivas ou recomendações, nós diríamos que Moçambique está a introduzir um sistema informático de tramitação processual. E neste processo do sistema informático, também pensamos que o envio e recepção de pedidos pode, de alguma forma, ser mais célere. Também apostar na formação e capacitação de todos os intervenientes na cooperação jurídico-penal. E, por outro lado, o estabelecimento de acordos de cooperação na região da África Oriental. E, talvez, por fim, também, como dizia o colega que me antecedeu, a harmonização da legislação e dos procedimentos da cooperação jurídica e judiciária em matéria penal. Em conclusão, dizer que a cooperação jurídica e judiciária em matéria penal é uma exigência incontornável no combate ao crime organizado e transnacional, no processo de assistência mútua legal e extradição, deve-se buscar estratégias para o cumprimento atempado dos pedidos. Os fóruns, como por exemplo este da Eaap, mostram-se relevantes no aprimoramento da cooperação no combate ao crime organizado e transnacional. Pela atenção que me prestaram, o meu Canimambo, Asante Sana, muito obrigada. Thank you, merci beaucoup.
Thank you very much, Deputy Attorney General, for those remarks. I noted something of concern. They have made 34 requests and only 4 were responded to. That's something for you to think about. Responded to, not refused, not accepted, responded to. So I'll request our next speaker, Rwanda, to come and share with us their experiences. But that's what Mozambique is saying is that one of the greater challenges is that you take too long to respond, even to acknowledge receipt. It is something that this meeting needs to really contemplate upon and think about. Thank you very much.
Good morning. My name is John Bosco Siboinhore. I'm from Rwanda. I'm a national prosecutor. And as I yesterday said, I'm representing the Prosecutor General who could not make it here because of national engagements. First of all, before, can my PowerPoint please? Okay. First of all, before I go into this sharing our experiences in these transnational crimes, I would like, first of all, to say that Rwanda knows that the fight against impunity is universal. And therefore, there is no way we can succeed if we don't domesticate laws that are going to facilitate international cooperation. And it is on the international cooperation that Rwanda, after post-genocide, the United Security Council establishing the ICTR, under their statute, they had a provision, Article 28, which requested all countries worldwide to cooperate, international cooperation. And it is on that note that most of African countries cooperated with the ICTR to hunt down, arrest the 93 persons that had committed genocide against Tutsi in Rwanda, who were roaming in capital cities as if nothing had happened. And it was the role of the international cooperation through mutual legal assistance that most of African countries, notably Kenya, Zambia, Cameroon, DRC, Uganda, and many others that cooperated so that the ICTR could start prosecuting. The rationale was to eradicate the impunity. And indeed, it did so. And at the end of the day, when the ICTR closed their work, they had prosecuted and convicted 67 out of 93. So had it not been the international cooperation, justice would not have been rendered in that regard. So maybe let me go back to the point now. Rwanda's legal system. Rwanda is a civil law country which is in recent years has shifted to the common law legal practice. And the constitution is the supreme law of Rwanda, and any other law that is inconsistent is void. Treaties need to be domesticated to assume the force of law in Rwanda. So we have domesticated, as I earlier said, that Rwanda has recognized that to fight impunity, you have to domesticate laws, you have to cooperate with the partners, you have to engage one another in order to succeed, because the transnational crimes we are trying to fight knows no borders. Criminals will shift from country A to country B, and if we only have laws that are going to be based on to arrest and cooperate, we are only going to succeed if we have those. So Rwanda, we got an extradition law, which the law of 2013, which we embark on. We also have the mutual legal assistance law of 5th June 2021, which also regulates the taking of evidence for foreign trials, the surrender of criminals found on Rwandan territory, and also ways of how to reciprocate the backing of warrants. You know, we have normally, when countries send indictments against fugitives who have fled to Rwanda, we have to respond to these responses based on the mutual legal assistance law of 2021. It was recently, actually it was promulgated after, during or after the COVID. So you see how serious our country is, and how it regarded this issue very important, to the extent that they regarded this as important because of current trends. So also, again, within that law, the law allows witness summons issued out of Rwanda to be served to any witness who is within Rwanda and to travel abroad to testify. Witnesses, we've been always sending witnesses abroad to testify in cases where they have seen criminals engaging in criminality and evading justice. And our law, this mutual legal assistance law, is very flexible to the extent that witnesses can be taken abroad to testify. The importance is not where the trial is going to be conducted, but rather justice to be served. Again, even incarcerated people in our prisons can be allowed to move out of the country and go and testify abroad. So, sorry, I'm short of but I'll continue. My laptop is out of power, but I continue doing this. But the rationale, the point I wanted to ride at is that even the mutual legal assistance law is very flexible to the extent that we can even allow the incarcerated persons to go outside and give testimony. So if, for instance, there is someone, because these transnational crimes, they have a component of universality, universal. Any country can try. So whether there are issues that are going to stop country B to extradite to country A, there still justice can be served. And it is on that ground that our law of mutual legal assistance allows to even send witnesses abroad, but not only that, also incarcerated people can also be allowed to move, to travel and come back after the trial has been completed. Can you give, yes, can you say, please, another slide, quickly. Yes, yes. Yes, these are the, come back again. These are the treaties we have signed, Rwanda have signed with other countries. As you can see, we have an extradition treaty with Uganda of 2005. We have the one of 2009 with Kenya. But we have, before we even signed bilateral treaties, we have also the block, the one of the ICGR of 21st June 1975. We have also one with Tanzania, which is actually very odd because it doesn't cover the current trends. The one that was signed in 1965 does not cover emerging crimes such as human trafficking, cybercrime, money laundering. So we need, and we've been talking, we need to again to amend it and have the one that is updated. We have one with the Malawi of 2017. We have another one with Zambia of 2017. We have also one with the Congo, the Republic of Congo. We have also another one with the United Democratic Republic of Ethiopia of 2018, and another one with the Mozambique of 2019. The recent one is of 2021 with Zimbabwe. So we have legal framework. We have not yet, although Rwanda is a Commonwealth member state, we have not yet signed the London scheme and the Harare scheme, which would be good avenues for extradition or mutual cooperation. Another slide. Yes, again, assistance is based on the principle of reciprocity. Any request for mutual legal assistance must be addressed to the competent authority, the Office of the Prosecutor General, through the central authority, which is the Ministry of Foreign Affairs. Continue. Another slide, please. Can you do it? You can't do it because this. Okay. Yes, the key components of this MRA, it must be submitted to the competent authority of the requesting state. Also must contain the following information as a minimum: specify authority taking request, specify details of the assistance required, contain a summary of facts, identity of persons being investigated, particulars of the charge. These are it is common to many mutual legal assistance. So also have documents translated into English or French because we use both languages. Also contain an undertaking to reciprocate similar requests from Rwanda. Also specify a person of contact. So what are the challenges? The challenges we have made from countries where we send indictments is lack of communicating back. Lack of communication is an issue. Also, fugitives, when you don't communicate and arrest fugitives, you give them a leeway to move freely. Again, fugitives change addresses in the requested state. They also change names and their nationalities and live in the requested state unrecognized. So what could be our recommendations? We need to have informal communication running. We need to know our common enemies, who are the criminals, and we should have no border, since criminals themselves do not have or do not know any border. We need to respond to correspondences through the appointed focal persons to avoid losing evidence, which, given some time, lose their meaning. I thank you so much.
Thank you very much, John Bosco. I think you have given me a new phrase which I'm going to go back with. The fight against impunity is universal. We are in it together. Crime knows no border. So all of you who are here need to remember that fight against impunity is universal. Our next speaker will be from South Sudan. You know, I'm enjoying this so much, I even forget that I am the one supposed to be moderating the time. But I just forget and I just keep enjoying, because now for me I'm in class, I'm learning everything. I'm the competent authority, and therefore I am learning everything that is struggling everywhere around the world. But I will try and remember that we have to deal with the time. Thank you.
Good morning, everybody. Especially the Attorney General of Uganda, who is the chair of these sessions, Madam Justice, Madam Justice, DPP of Uganda, Justice Jane, I'm very happy, sincerely, of your well-organized these 10th meetings in Uganda. And it gives a new blood to our organizations to grow healthy and to be exemplary organization in the region. Every day you surprise us with the good organization. We thought Mombasa is the best, but this is the best of all. My greeting also go to my colleague, DPP, Attorney Generals, Prosecutor General in the region who were attending this meeting, and also to our partners who make this possible to us. To go back a little, South Sudan is the newest country in the Africa. It took independence in 2011 after a long year of fighting for their freedom. Since 1955, for 17 years with Sudan, when we are in one Sudan, for our liberation. And then again for 21 years, until we reached the agreement in the Fasha in 2005. And then we got our independence. South Sudan came out of war, and it has many challenges. Among these challenges is uncontrolled borders, for we are neighboring 6 countries. These 6 countries is Sudan in the north, Ethiopia in the east, Kenya and Uganda in the south, DRC in southwest, Central Africa in the far west. So these borders is uncontrolled border, and it is a challenge to us to combat or to control the organized or transnational crimes which cross, and we are the transit country for all these crimes. So South Sudan also face many challenges, laying foundation to united, peaceful, and prosperous society based on justice, equality, rule of law, and human rights. Also, South Sudan, as a country, faces organized crimes in terms of corruption. So that when there is corruption, you cannot do anything. All the money, all the resources will go to individual, and you will not be able to realize your goals, especially on the term of combating crimes. So also illicit financial flows, a return of such funds. If you remember, in 2015, we, as the Minister of Justice, Directorate of Public Prosecutions, we filed a case against the Office of the President of some individuals who misappropriation the funds of the office, and we persecuted them. That the President said that you begin with my office to fight corruptions, and we investigated them, we persecuted them, we tried them into different sentences. Also, illicit or financial. South Sudan is a country that attracts all the investors in the region, especially our neighbors. They were there in South Sudan, and they are practicing the business. And this one also will lead to the illicit of the financial flows. They don't follow it, the right procedure that they deposit their money to banks, that will go, but they take it in cash. So this also is our challenges. South Sudan also facing of money laundering, human trafficking. And human trafficking, as I said, South Sudan is a transit country with our neighbors. They transited to South Sudan and then to the north. They went to Sudan, from Sudan to Libya and others. South Sudan also faced with drugs. And these drugs also is a challenges to our, although we have laws on these offenses or these crimes which I mentioned. Either it is corruption, we have anti-corruption law, we have drugs laws, 2006. We have small arms. For South Sudan came out from war, arms are still spread in the individuals, and that make always community violence, instability, and also it is the exit from all the countries which I mentioned before. We have another challenge, wildlife and conservation crimes. We have laws to combat wildlife crimes since we are in war, 2003. It is in place, but now we are working with our partner, which is called Space for Giants. They are the one also now working with us to give training to our public prosecutors, and also we are working on mutual legal assistance with them, and also to draft for us laws for wildlife, or to amend it. For South Sudan faces, or our public prosecutors in South Sudan faces cases of sexual and gender-based violence. So this area, we are working with our partner, UNDP, human rights with United Nations mission in South Sudan. On this, they are helping us, and we have a special code for gender-based violence, protecting children and women. Also, we have child soldier as challenges. Most of the children who were involved in the war, we have to return them back to school, or to make them to observe them in DDR process commission. Also, we have cases of children in conflict with laws. We have law, Child Act. Law is in place 2006, and 8 is there in its place, and now we are modifying some remedies to the children who were in conflict. We don't face it sometimes. Those who were in conflict in the law, they don't have separate cells to be investigated there. Always you find them with the adults in cells or in custodies. We are trying our level to have their centers alone and so on. We have the lack of training to the criminal justice system in South Sudan. South Sudan came out from war. When we are united in Sudan, they are facing the language. Which language we are using it in our prosecution or in criminal justice. We use Arabic. When we came out of war, we used Arabic, and still now we use it, but in our constitution, it is stated that English is the official language. But in terms of investigations, you find the offenders are not speaking English. You have to investigate them into the language they understand, that is Arabic into English, or from English into other languages. So we have been given opportunity to have this training on English either in Kenya or in Uganda or in other area there to train our prosecutor or the criminal justice system, either just judges or the investigators, the police. We have the second challenge is the mutual legal assistance on areas on forensic laboratory analysis on dangerous drugs. When we apprehend any suspect in questions, we don't have lab to analyze these drugs. But we have good relation with Sudan still. We send them to be analysis. Yes. Okay. To be analysis. And Rwanda are our partners also. In terms of extraditions, or South Sudan is yet accede to United Nations Organization Organized Crime Conventions and its protocols. We are working on it. Now we have the National Task Force to accede to the United Nations on transnational crimes. We have some treaties that we are Accessory to United Nations Convention on Corruption 2006, Convention on Rights of Child and Sale Children, Child Prostitutions and Pornography. We signed it. South Sudan Police is a member to Interpol agreement. South Sudan is a member to the East African Inspectors Police. National Task Force for Committee for Combating Human Trafficking was there in place. South Sudan National FIUs is there, and money laundering. And then recently we signed SIDAWA, which will protect our women, and we become member of it. Thank you very much.
Thank you very much, Honorable DPP from South Sudan. He has told you that we have uncontrolled borders. I don't know whether we should call them lines, because we are one people. So it is a problem you have. You have a line, but it is uncontrolled. In fact, uncontrollable. I'll request the DPP from Tanzania or representative from Tanzania to come and make their remarks. But we are running out of time, so I'm requesting that we keep within the framework of the time that we agreed. Thank you.
Thank you very much, Honorable Iji, and the chair of this session, for according me the podium, and for the privilege of addressing this important delegation. I also take this opportunity to introduce myself as per your guidance. My name is Mr. Faraja Nchimbi, Acting Director, Asset Recovery, Transnational and Specialized Crimes within the National Prosecution Services of the United Republic of Tanzania. The 8 minutes that have been accorded to me do not give me the privilege of being too verbose. So, as guided by the chair, I'll go straight into highlighting some of the efforts, challenges, and the plans that the NPS on behalf of the URT has put in place with regard to bolstering international cooperation. Yeah, Tanzania, like most of you here, embraces the reality that international cooperation in the form of MLA and extradition is so far the most effective tool in combating transnational organized crime. And we are also alive to the fact that in order for the URT to effectively provide the widest measure of international cooperation, it must have in place robust legal and efficient institutional frameworks. It is out of this context that the URT has ratified a number of international conventions, some treaties, and also regional instruments that provides and caters for the international corporations. We have ratified the International Convention Against Transnational Organized Crime, International Convention Against the Corruption. We are also members and to the Commonwealth schemes on international cooperation, and a lot of regional treaties. And in order to demonstrate these international instruments, Tanzania has enacted 2 major legislations to provide for international cooperation. We have the Mutual Assistance in Criminal Matters Act, which is KEP 254, revised edition 2022. I will hereinafter refer to it as the MACMA. And we also have the extradition of fugitive criminals, as governed by the Extradition Act, KEP 268, revised edition 2019. According to the MACMA, the DPP is designated as the central authority in all matters relating to mutual legal assistance, and the minister responsible for constitutional and legal affairs is the central authority on matters relating to extradition. Now, if I may move straight to the efforts that have been undertaken by the URT in bolstering international cooperation, we have about two major categories of efforts. The first one is on the legislative amendments on all important legislations that deals with international cooperation. To start with the MACMA, following a series of meetings of this nature and the conferences of other regional bodies and associations like this one, Tanzania found it imperative that we go back and review our legislation. Because it's one thing to have a legislation in place, but it's another thing to have a legislation which can effectively provide for matters of mutual legal assistance in practical realities. So in 2018, we made a review of our MACMA, and through it we found a number of areas that needed improvements. We looked at them as areas which impedes the efficacy of the URT in providing the widest measure of international cooperations in combating crime. And in that, I'll highlight some of the major areas that we thought it was imperative to make some amendments. The first one was the designation of the DPP as the central authority. Before that, the central authority on matters relating to mutual legal assistance, before 2018, backward, was the Attorney General. I would say to a great extent that posed a major challenge in the processing of these requests, especially the incoming as well as outgoing. Because the DPP is the central authority. The DPP normally is the competent authority in all matters relating to criminal, and the DPP is in control of all criminal proceedings. The AG, of course, has a number of other mandates, some of which included processing of the mutual legal assistance requests. Now, this had attributed to a lot of delays in the processing. Documents could be losing track between the office of the DPP and the office of the AG. And in most of the cases, the AG would be forced to receive a request and have it channeled to the DPP, send his personnel to the DPP so that they can work together. So by amending our act, now the DPP is the central authority, and now that is expedited and shortened the time in which these requests can be processed in the office of the DPP, and we can see some improvement in how these matters are being handled. I would say, for sure, things are changing. Also, we all agree that there have been a lot of delays in processing these requests, as in some of the jurisdictions, the requests are forced to go through diplomatic channels. Now, we looked at this, and this has been discussed in a number of conferences, the Eaap included, since 2010. And we thought now it's high time that we amend our legislation, do away with the requirement for transmission of requests through diplomatic channels. And for now, our legislation allows the DPP to transmit documents straight to the DPP Kenya without recourse to the diplomatic channels. And again, we have seen how this has contributed to the efficacy of the NPS, or the DPP for that matter, the central authority. Also, we looked at section 4. As we have been saying, over time, transnational organized crime has been evolving. New forms of offenses have been emerging. And we have been saying that criminals have been changing their tactics, adapting to the advancement in technology and science and technology. And we thought it was pertinent now for us also to go through our legislation, look at it and see whether it is up to the international standards currently in combating transnational organized crime. And we were forced to amend Section 4 of the MACMA and widen the scope of assistance, where now we added more or less like 7 areas of assistance, including tracing, seizing, and confiscating of proceeds of crime. This was not in our legislation before 2018. Enforcement of foreign forfeiture orders, preserving and obtaining all forms of computer and telecommunication data. We now know how information technology is useful in committing crimes. Preserving interception of postal items, interception of communication data. Now we can offer assistance in covert electronic surveillances. We can also facilitate the taking of evidence by video conferencing, also carrying out covert operations and a controlled delivery. These are some of the areas which were not in our legislation before 2018. As regards to the Extradition Act, Section 15, Capital A was introduced in the Extradition Act, which assisted in giving the DPP the mandate to make application to court for reciprocal backing of warrants of arrest from foreign jurisdiction in order to make the process of extradition more expeditious. Again, at institutional level, we found it important to invest a lot on trainings to prosecutors on MLA and extradition, widening the pool of experts in the area, working along with international partners, including UNODC and others. We have also intensified engagement with practitioners from competent authorities. Last year, September, our DPP instructed me to prepare a conference for all competent authorities within the United Republic of Tanzania, where about 19 authorities, which in one way or another are involved in one way or another in the execution of these requests, convened in Dar es Salaam, where the DPP highlighted to them on the importance and their roles as competent authorities in execution of requests, aiming at bolstering international cooperation. Now, and as of now, we have already established a network of these competent authorities, 19 competent authorities, through WhatsApp groups, and we continue to exchange. We continue to exchange information on important aspects that relates to international cooperation. And we are also engaging with other development partners and using the government resources, trying to, as much as possible, to equip these competent authorities within the URT so as to make them up to the standards in implementing their obligations as the competent authorities. But also develop guidelines for foreign central authorities, because it's very important that the outside world, the foreign central authority, should know if they want to make a request in the URT, for instance, what is it that they need to do to make sure that the request is processed in a manner that is acceptable in the URT. So we have prepared this guide to foreign authorities, and it was launched in 2018, and we have also uploaded it in the website of the NPS, and it's being very useful to the international community, and we can measure that through the increased requests that comes in, which we can see they are all in alignment with the guide that has been provided. The DPP is also developing internal SOPs. We have already prepared the zero draft of that, and by March we will have these in place, which will aim at guiding all competent authorities and prosecutors working in implementation of the directives of the DPP to make sure that they are compliant to international standards. Again, we continue to review our legislation in order to make them more compliant to international standards based on the international conventions and the FATF recommendations as pointed in the previous presentations. Challenges. There are a lot of challenges that have been highlighted, and very regrettably, most of these challenges are being repeated day and day, conference and conference. I'll also repeat them again, but also I think in the end I'll call upon this delegation, this meeting, to reflect on how we can move from here, because if we go through some of the challenges that we shared last year and the last year, you may find that we are repeating on the same challenges. 12 years now. Now, the first one is delayed response to requests. The Madam Deputy AG from Mozambique has highlighted on this. This is a very big challenge. Also non-responsive of the central authorities. I'll be candid in this. At times, it's easier to get a response from Australia or Austria than it is easier to get a response from one of the countries within the African region. But we are here. Protracted process through diplomatic channels. We have been singing this time and time and time. On our part, we have done our best, and I believe Kenya has done the same, and the rest of you colleagues, in trying to do away with these diplomatic channels. Now, we have amended our legislation, but still, we can't have it. The amendment does not give that impact needed, because you will go to a certain country, you find that they still want you to channel it through the diplomatic channels. Now, as the EAP, we need to look at this and see how we can move from here forward and stop from complaining on this charge. Now, disparities in legislative provisions, this has been spoken a lot. I also reiterate it and request us to reflect and see how best we can move away from these complaints and focus on other challenges that are real on the ground. Plans to improve continued capacity building to practitioners. As appointed, the DPP started by calling all competent authorities in the URT, and that is a continued process. We'll be having those conferences mostly annually. And in that also, our DPP is fighting to make sure that at least we have a center of excellency for training practitioners in the URTs, in the areas of international cooperation and other areas, and he has been working day and night, calling upon development partners and other stakeholders to see how this dream can be realized. Enhanced coordination at domestic level by increasing engagement with competent authorities. I've spoken about this. Completion of the internal guidelines and SOPs. As I said, by March, we'll have this one in place. And again, for now, we are moving toward trying to make this process of MLA as swift as possible. Now, thanks to my DPP, Mr. Sylvester, in Tanzania, we can even accept electronic copies of requests, and I will start working on them. By the time you bring your hard copies, you will find that already most of the work has been done at the groundwork. And the DPP, when he receives such requests, can even send one of his technical experts the request through WhatsApp with instruction that it need to be immediately attended. All this is trying to see to it that some of these requests are processed in a timely manner and in a way that that will improve our performance as a central authority. Now, in conclusion, I would very much request sincerely that we as members of the AAP should first acknowledge that international cooperation is to be an important tool in combating transnational organized crime. But in order to harness the best of it, it's important that we unconditionally commit ourselves in supporting the work of central authority within the region and to make the region free from crime and a safe haven for children and women. And for that, I would reiterate the recommendations given by some of my colleagues. One, we need to improve on informal communication between these central authorities. I would challenge, for instance, the DPP Zanzibar, DPP Zambia, ask your technical personnel in the MLA desk, how many contacts do they have within the region? Can he, within 5 minutes, pick a call and call a contact in, say, Tanzania or Kenya, and ask, hey, I have this and this and this, can you assist? Of course, I know at the level of you as DPPs, you can easily do that. But how many requests can be executed based on the communication between the DPP and the DPP? So I request for such commitment, and I believe in order to achieve that, first, I would suggest that in the future, if agreed, some of the recommendations that are set here, the resolutions, we should have time to reflect on the implementation. That is one. Also set a mechanism or improve the existing mechanism for review on the pace of implementation of the resolutions. And lastly, encourage members to have all focal persons of the central authorities listed and, if possible, shared through the EAP website so that we can easily access. Mr. Chairman, thank you for time spent, and I thank you very much.
Thank you very much, Mr. Faraga from the United Republic of Tanzania. We appreciate it. As we prepare to listen to Burundi, I've noted that the theme of his presentation was the need for legislative reform, which is effective in the practical realities. Obviously, I was a bit concerned, in Uganda here I'm the central authority, but I'm not going to highlight the part where he was removing the Attorney General, because I think I may leave the room without a job. But I think we'll have to look at it properly and see how really effective it is. But I thought Burundi, thank you very much, United Republic of Tanzania, we appreciate that. Representative from Burundi, thank you.
Merci, Monsieur le Président de la séance, de m'accorder la parole. Je voudrais d'abord commencer par remercier les autorités de l'Ouganda à travers le DPP Jane pour leur accueil chaleureux durant ces assises. Merci pour votre hospitalité. Je voudrais vous partager l'expérience du Burundi pour ce qui est de l'exploitation des lois internationales dans la lutte contre le crime transnational ou le crime organisé. Et parmi ces crimes, il y a le terrorisme, la traite des êtres humains, le blanchiment des capitaux et la corruption, ainsi que d'autres crimes qui peuvent se commettre à travers plusieurs États. Et comme vous le savez, le monde, à travers le développement des TIC, est devenu un village, et ce qui accroît les risques de commission de crimes transnationaux ou de crimes organisés. En plus, les pays font partie de plusieurs ensembles régionaux ou continentaux. Et pour l'accomplissement de leur mission, il y a l'adoption de plusieurs protocoles, et notamment les protocoles relatifs à la libre circulation des biens et des personnes. Et vous comprenez que ces protocoles-là, avec ces protocoles, le libre mouvement des personnes et des biens accroît le risque de coopération des personnes dans la commission des crimes transnationaux. Bien sûr, le Burundi fait partie de plusieurs textes, de plusieurs traités internationaux. Je citerai notamment la Convention internationale contre la corruption et le blanchiment des capitaux, et la Convention internationale contre la traite des êtres humains et l'exploitation sexuelle, ainsi que d'autres. Et sur le plan africain, le Burundi fait partie de la Convention de l'Union africaine contre la prévention, pour la prévention de la corruption et pour la prévention et la lutte contre la corruption. Et se basant sur ces conventions internationales dont le Burundi fait partie, le Burundi a mis en place des lois nationales pour renforcer la lutte contre ce genre de crimes. Et c'est ainsi que le Burundi a mis en place la loi numéro 1/02 du 4 février 2008 portant sur la lutte contre le blanchiment des capitaux et le financement du terrorisme. Et cette loi prévoit en son article 12 une cellule de renseignement financier qui est maintenant à l'œuvre pour s'harmoniser avec des autres cellules. Et je vous dirais que cette cellule est en train de visiter d'autres cellules pour l'échange d'expériences. Et le Burundi entend être membre de l'Eastern and South Africa Anti-Laundering Money Group. Et je pense que le Burundi va bientôt être accueilli comme membre de ce groupe. S'agissant de la traite des êtres humains, le Burundi, se basant sur la Convention internationale, a mis en place une loi nationale, la loi numéro 1/28 du 29 octobre 2014 portant sur la prévention et la répression de la traite des êtres humains et la protection des victimes de la traite. Et actuellement, le Burundi a des avancées significatives, notamment dans le domaine de la formation des magistrats par rapport à la répression des infractions relatives à la traite des personnes. Nous avons constaté qu'au Burundi, la traite des personnes était ces derniers temps basée sur des gens qui allaient s'embaucher dans les pays arabes pour chercher de l'emploi, mais ils y allaient illégalement. Et c'est ainsi que le Burundi a mis en cadre légal pour permettre à ceux qui veulent aller travailler à l'étranger de le faire dans toute légalité. Et nous avons constaté que cela concernait beaucoup de femmes qui allaient s'embaucher dans les pays arabes comme l'Arabie saoudite, Oman et ailleurs, comme des femmes de ménage. Et là-bas, comme elles y allaient sans un cadre légal précis, il y avait parfois des cas de maltraitance où des femmes étaient malmenées ou renvoyées sans être payées. Et c'est pour cela que le Burundi a dû mettre en place un cadre légal. Le Burundi fait des efforts pour lutter contre la criminalité transnationale, et cela se fait à partir des poursuites engagées par le parquet général de la République avec les autres parquets. Il y a aussi la police judiciaire qui a à son sein une cellule chargée d'Interpol. Et ici, je vous dirais que le service Interpol nous aide beaucoup parce que la mise en œuvre des conventions internationales est très problématique. Et pour le moment, nous continuons à utiliser fréquemment la voie diplomatique, les services d'Interpol, ainsi que bien d'autres mécanismes bilatéraux. Il y a aussi une brigade spéciale anticorruption qui traque les personnes coupables de corruption et qui confectionne des dossiers pour les transmettre au parquet général anticorruption. Alors, dans la lutte contre ces infractions, il y a des défis. Et les défis majeurs auxquels nous faisons face sont notamment la bureaucratie. La bureaucratie, ici, je parlerai de la lourdeur des procédures. Quand vous demandez une information à un autre État, vous devez d'abord passer par le ministère des Affaires étrangères pour qu'il puisse vous transmettre, vos demandes à l'autre État parti, ce qui allonge tellement la procédure et retarde les jugements. Il y a des lois qui ne sont pas très claires sur les autorités compétentes. Parfois, on vous dit c'est le ministre, ailleurs on vous dira que c'est le procureur général, ailleurs on vous dira que c'est le DPP. Donc, il faut une harmonisation. Il y a aussi un manque de guides pratiques, de références pour tous les États. Il y a aussi des lois discordantes ainsi qu'une mise en œuvre des conventions internationales qui n'est pas bien en place parce qu'il y a des mesures d'application qui doivent être prises par certains États et qui ne sont pas là. Quand il n'y a pas de mesures d'application pour une convention internationale sur le plan interne, il devient difficile de la mettre en œuvre. Ça, c'est aussi un problème. Alors, comme perspective, nous entendons poursuivre l'opérationnalisation de la loi anti-blanchiment ainsi que l'opérationnalisation de la série de renseignements financiers ainsi que son adhésion à l'East African Anti-Corruption, Anti-Money Laundering Group. Il y a aussi le renforcement de la coopération judiciaire dans le cadre régional et international. Comme nous avons vu qu'il y a un défi lié au manque de formation des magistrats sur le traitement de ce genre de crimes, nous comptons entamer une procédure de formation des magistrats et des acteurs qui sont impliqués dans la lutte contre ce genre d'infractions. Bien sûr, nous poursuivons la mise en œuvre des différentes conventions avec une clarification sur l'autorité compétente. Voilà, Monsieur le Président, la petite expérience du Burundi. Je vous remercie.
Thank you very much, Prosecutor General. I'm sure Burundi is the one that sends out its requests quickly because they seem to be clear on guidelines. Time, they've met it well, so I'm sure their responses are timely. But the theme in Burundi's presentation is that the increased free movement of goods and persons exposes us to transnational crime. Think about that as we now receive the remarks from the Democratic Republic of Congo. Ladies and gentlemen, currently I am the highest ranking government official in this room. So I'm going to exercise my executive authority to take away your ability to have your break. So we shall break at once at the end of this session, and that's an executive order. I don't know where it sits in the MLA guidelines, but we shall find something along the way. Democratic Republic of Congo, please.
Je serai très bref et très concret. Chers collègues, différentes délégations, tout en vous saluant, en saluant votre présence dans la salle, je voudrais dépasser tous les concepts que nous connaissons, c'est-à-dire, toutes les définitions restent les mêmes. Crime transnational, crime transfrontalier, les crimes, on les connaît, les criminels sont définis. Nous savons quand est-ce qu'un crime est considéré comme transnational. Ici, la problématique demeure, celle de savoir Merci beaucoup, madame, mes chers collègues. Moi, c'est le procureur général près la Cour de cassation de la République démocratique du Congo. Je suis, selon la législation de mon pays, le ministère public au sommet. J'ai la compétence pour la répression de toutes les infractions, j'ai la compétence nationale. Je suis à la tête de 27 procureurs généraux qui sont dans les différentes provinces de la République. Je contrôle l'action publique au sommet, toutes les poursuites publiques. J'en suis et j'en réponds. Je suis donc l'unique responsable en RDC et dans les développements qui vont suivre, je vous dirai que l'autorité du ministère public au sommet dans ce pays, ou l'autorité centrale, c'est moi, le procureur général près la Cour de cassation, selon la législation en vigueur dans ce pays. Tout en vous remerciant d'avance pour votre attention, comme je l'ai dit, je vais être très pragmatique. Lorsque nous parlons de l'entraide judiciaire, de la coopération internationale judiciaire, nous entendons par là que les pays qui sont voisins les uns les autres ou même des pays qui ne sont pas voisins, parce qu'on peut commettre un crime dans un pays, prendre un avion et parcourir les airs, atterrir dans un autre pays. L'entraide judiciaire signifie qu'il y a un criminel qui a commencé quelque part et qui se retrouve en dehors du lieu où il a commis l'infraction, mais qui est un autre pays, et son crime devrait être réprimé. J'ai des constats malheureux à faire. La RDC, vous le savez, c'est un État qui est incontinent. Hier, monsieur on l'appelle Chief Justice, honorable Mao, commençait à citer les pays qui font frontière avec l'Ouganda. La RDC en a 9. Alors, de tous ces pays, il est question de coopérer avec eux. Le problème se pose, celui de la sincérité. Il y a 3 ans, à Livingstone, la PAS se réunissait, c'était autour du thème traite des personnes. Il y a 4 mois, on se retrouvait encore à Maputo. C'était autour du trafic, ou plutôt du terrorisme, du blanchiment, du financement des capitaux et des extrémismes violents. Il y a 1 mois, la RDC s'est retrouvée encore à Mombasa, dans le cadre de l'APA. Ici, nous nous retrouvons dans le cadre de l'Association des procureurs des États de l'Est. C'est pour dire que la RDC, qui est un continent, s'implique dans toutes les associations dont il peut faire partie. Je voudrais encore citer la CIRGL. En juin dernier, 8 des pays membres de l'Eaap étaient présents à Kinshasa. Là aussi, c'était une association, nous avons parlé de la coopération internationale. Alors, les problèmes se posent où? Les problèmes se posent lorsque il faut passer aux actes. Il y a 1 mois, j'ai parlé encore à Maputo, ou plutôt à Mombasa, des crimes environnementaux et des crimes maritimes. Les crimes environnementaux impliquent tous ces crimes qui sont liés au vol, à la spoliation des matières, des ressources minières. Les crimes maritimes, c'est dans les cas de piraterie en haute mer, dans les océans. Et là, je disais encore, puisque nous sommes en train de parler de la coopération et de l'entraide judiciaire, pensez-vous qu'il y ait de l'honnêteté lorsque un criminel bien connu se retrouve dans un pays voisin et que fait de ce pays, à force de la récurrence de son trafic ou de son trafic illégal, fait de ce pays au top de certains producteurs de telle matière, alors que sur son territoire, il n'en est pas producteur. La coopération devait être sincère. J'avais parlé de l'implication des hommes politiques. Nous ne parlons pas politique ici, mais il est évident que sans l'implication de l'homme politique, tout ce que nous ferons ici n'est que lettre morte. Nous prendrons des résolutions qui ne seront pas des résolutions concrètes. Monsieur le procureur général, monsieur le ODPP, j'ai promis de ne pas m'étendre. À Kinshasa, en juin dernier, j'ai été désigné autorité centrale pour la coopération judiciaire. Notre pays, mon pays, la RDC, aligne dans sa législation toutes les lois relatives à une, ou plutôt prédisposées à une bonne coopération internationale, que ce soit sur le blanchiment d'argent, que ce soit sur la traite des personnes, que ce soit sur le financement du terrorisme. Nous avons toute une panoplie de lois, alors des lois spécifiques. Au départ, c'était le code pénal, mais nous avons fait l'effort. Il y a encore eu 1 mois, on renouvelait la loi sur le financement des capitaux et le blanchiment d'argent. C'est pour dire, côté de la législation, la RDC est à la page. L'application pose problème et nous savons que quand il y a coopération, se pose directement le principe de réciprocité. Je voudrais, en ce qui me concerne, chers collègues, procureurs généraux, que nous puissions nous regarder parfois en face pour dire est-ce que nous sommes sincères dans cette coopération qui exige la réciprocité. C'est une simple règle diplomatique. Mais lorsque nous venons crier ici, sur cette tribune, coopérons et que nous sommes loin de concrétiser ce que nous avons sur papier, je crois que nous ferons du surplace. Ça fait combien de temps que nous parlons de la coopération judiciaire? La RDC coopère très facilement avec la Cour pénale internationale. Les exemples sont légion. Vous avez entendu parler de Bemba, vous avez entendu parler de Taganda et autres. Chaque semaine, je reçois toujours des commissions rogatoires de la Cour pénale internationale. Du côté de l'Afrique, dans les différents sous-groupes, que ce soit la SADC, dont mon pays est membre, que ce soit le CEAC, dont mon pays est membre, que ce soit aujourd'hui les États de l'Afrique de l'Est, dont mon pays est membre, que ce soit la CIRGL, partout nous y sommes, compte tenu de la dimension immense de notre pays, et partout nous sommes bons élèves. Nous sommes au regret, je ne voudrais pas être trop explicite, mais il y a des mandats internationaux qu'on appelle commissions rogatoires internationaux, ou soit des mandats d'amener, envoyés par différents services, qui souffrent de leur exécution jusqu'à ce jour. Chers collègues, je voudrais terminer, parce que c'était très peu, terminer en disant que j'étais très pragmatique. Je voudrais qu'au-delà de notre volonté à nous, qui sommes les organes poursuivants des infractions, interroger aussi l'homme politique. C'est vrai, sans cet homme politique, sans des outils diplomatiques, politiques, nous ne pouvons rien faire. Mais tant qu'on a des traités qui sont déjà signés, qui sont déjà formalisés, et que nous nous éloignons en pratique de l'exécution conforme ou ponctuelle de ces traités, nous pouvons nous dire que notre travail sera toujours vain. Voilà pourquoi, tout en terminant et tout en vous remerciant pour toute l'attention que vous avez soutenue, je fais les plaidoyers pour que, dans nos pays respectifs, nous puissions, d'une manière ou d'une autre, regarder parfois l'autorité politique en face ou lui faire des avis techniques pour que nous ne soyons pas ridicules nous-mêmes dans nos différents forums ici, pour que nous puissions allier le texte à la réalité. Nous avons dit et je vous remercie.
Thank you very much. Thank you very much. He says there is need for sincerity in the practice of MLA cooperation and the fight against transboundary crime. We request now the remarks from Ethiopia, and DRC has reminded us to ask for more from the politicians. I want you to go and read Oliver Twist and remember what happened to Oliver Twist when he asked for more. Thank you very much, Ethiopia.
Good morning, everyone. My name is Barakat Mamu. I am Chief of Staff of the Office of State Minister in the Ministry of Justice, Ethiopia. Thank you very much for giving me this chance to present our first challenges and plans in relation to mutual legal assistance and extradition in criminal matters. As you know, transboundary crimes such as trafficking in person, especially women and children, smuggling of persons, money laundering, narcotic trafficking, terrorism, trafficking and smuggling of firearms, cyber crimes are among the notable Ethiopian national security threats that demand practical cooperation with other neighboring and regional and global states. To counter and suppress these crimes naturally requires the concerted and organized efforts of nations Ethiopia has been exerting diverse efforts at national, regional, and global levels. Diverse legislative, administrative, and judicial measures have been taking place to combat these national security threats. First, the country adopted Proclamation number 1263 that established central authority, which is the Ministry of Justice, to mandated to decide and process matter of international cooperation in legal affairs, mutual legal assistance both in civil and criminal cases, and extradition. Per this law, the Ministry of Justice has established particular departments responsible to these tasks, which is called International Cooperation in Legal Affairs Departments, which is interested to facilitate, cooperate with other states, and like departments or organizations in other states. As a central authority, the ministry to decide on process of international cooperation, legal affairs, and to other countries, receive and decide on requests from other countries. It also sends cooperation requests to other nations, exchange information informally with other states, peer institutions to base for formal cooperation. The ministry also has mandate to take actions that would help to prevent, suppress, and investigate, as well as prosecute transboundary crimes. In the ministry, AG or Attorney General, or in other country, DTP, is under the ministry. It is entrusted to prosecute and investigate these transboundary or transnational crimes. The ministry also developed and enacted and put in force different strategies to prevent and suppress trafficking person, smuggling in person, crimes of terrorism, and crimes of firearms trafficking. And these strategies, there is a part which talks about mutual legal assistance, extradition, and how the country interacts with other country to share information about these crimes and to suppress and to prosecute perpetrators. Second, the country has also entered into multilateral and bilateral treaties with specific countries that are crucial in combating transboundary crimes and facilitate mutual legal assistance and sharing of information. Ethiopia has entered bilateral treaties with Sudan, Djibouti, Yemen, Uganda, Rwanda, and China that has relevant to international cooperation in criminal matter, encompass extradition and mutual legal assistance. It also signed treaties with Turkey and UAE, which are pending for ratification by legislature. My country also proceeding to sign agreement with India, South Africa, Kenya, and Saudi Arabia to facilitate international cooperation with to extradite perpetrators and share information. At regional level, Ethiopia has ratified Intergovernmental Authority on Development, that is IGAD, a convention on extradition and mutual assistance, but this convention is not enforced because of lack of signatories. Only Ethiopia and Djibouti are ratifying this treaty or convention. This treaty is very crucial to cooperate regionally to facilitate mutual legal assistance and extradition. So other countries are requested to accede to this treaty. Moreover, Ethiopia is a member of multilateral treaties at global and continental as well as regional level relevant to fight transboundary crimes. For example, Ethiopia is part of the United Nations Convention Against Transnational Organized Crimes, United Nations Convention Against Illicit Trafficking in Narcotic Drugs, Psychotropic Substances, other relevant treaties or conventions. When we come to our challenges we have faced in relation to mutual legal assistance. The main challenges are, first, lack of effective coordination and communication among states, formally, informally, to share information expeditiously that needed to suppress, investigate, and prosecute transboundary crimes. Secondly, inadequate professional in the ministry or in the department that's interested to facilitate the mutual legal assistance are the main big challenges. And also, there are resource constraints to undertake the responsibility of mutual legal assistance and extradition of perpetrators. Our plan for the future are first, strengthening the legal framework of cooperation, including putting into force the Eaap Convention on extradition and mutual legal assistance, and signing further bilateral treaties between neighboring states to coordinate and facilitate mutual legal assistance in order to prevent and suppress transboundary crimes. Second, our plan is enhancing and strengthening cooperation, coordination at national and regional and global levels. Thirdly, establishing required infrastructure and mechanisms or systems for strengthening cooperation between regional and global partners, including developing digital information sharing system and building national, regional capacity for cooperation. I conclude here. Thank you very much.
Thank you very much, Ethiopia. He reminds us to recognize the need to and enter into treaties, agreements, and conventions on mutual legal assistance. Thank you very much. I now request remarks from Malawi.
Thank you so much for giving me the opportunity to speak this morning. My name is Masao Kocham Kakala. I'm the Director of Public Prosecutions from Malawi. Chairperson and distinguished delegates, I'll be brief, and I can assure the Chair that I'll be within my 8 minutes allocated. I'll start by giving a small background in terms of the offenses, the transnational offenses which are affecting Malawi currently. The major one is the human trafficking, which is quite serious as we speak. We've got cases especially from Ethiopia, Burundi, and of late we have also had some cases from Nepal. The destination appears to be South Africa and others beyond. There's also a proliferation of wildlife offenses, which are basically because Malawi is a source, and it also appears to be the distribution point for these offenses, and the destination is Thailand, Vietnam, China, and in some cases within the region. As already stated before, there are a lot of financial crimes in the region, including corruption, money laundering, and some of our concerns are located in Tanzania, Zambia, Kenya, and other states beyond. There's also a lot of smuggling for various reasons, some of them to evade duty, some of them to simply use Malawi as a conduit to destinations far and beyond. And of late, we have had concerns with the terrorism, especially with the developments happening in the Republic of Mozambique. We do have legal instruments which are trying to address the issues under discussion here. The international instruments include the SADC Protocol on Mutual Legal Assistance in Criminal Matters, the UN Convention Against Transnational Organized Crime, the UN Convention Against Corruption, and many other bilateral agreements which are signed under the Extradition Act, which in Malawi allows the minister responsible for foreign affairs to enter into such agreements. On the local scene, we have the Extradition Act, We also have the Mutual Assistance in Legal Matters Act, the Financial Crimes Act, and the Criminal Procedure and Evidence Code, which are guiding the issues surrounding mutual legal assistance. In terms of what is happening now, there are quite a lot of limitations on how these instruments can be applied. The first one is that as a country, most of you might be aware, thank you. As most of you might be aware, Malawi is not one of the most developed countries, meaning that the resources we have are quite tight. Some of the requests coming from the members here require a lot of resources, such that we cannot manage within the period given to respond effectively. There have also been requests which cannot be accommodated simply because they do not fit within the legal prescriptions of the country. Again, there's also that problem of dual criminality, which was already spoken to at length. The nature of assistance which we do provide under the MLA are as follows. We do locating and identifying of persons of interest, obtaining physical objects or evidence by search and seizure, arranging attendance of persons to give evidence, transferring of accused persons or persons of interest to the requesting country, and serving of legal and other such documents within the boundaries of Malawi. The competent authority for this is the Attorney General's office. However, because of the nature of most of these requests, the office of the DPP has been delegated to assist in these matters on behalf of the Attorney General. I'll briefly talk about extradition because it is one of the most slippery areas as far as we are concerned. As already stated, the issues surrounding extradition, they are governed by the Extradition Act. And within the Act, it is provided, as already said, that the minister responsible for foreign affairs can enter into bilateral agreements. As we're speaking, we only have bilateral agreements with Rwanda as of the membership which is here. And I think Rwanda will agree that upon signing this agreement, the processes have been much easier and much quicker in terms of responding to the requests. So it is our wish and plea that the members here should consider entering into these bilateral agreements with the Malawi government so that your requests can be easily handled just the way we are doing with Rwanda. If we do not have those agreements, I'm sorry, we have to use the existing international protocols, which, as some of you know, they're quite cumbersome and they're easily being challenged within our courts. Lastly, Chairperson, let me take stock of the challenges which are affecting Malawi as regards mutual legal assistance. One is the one which I just concluded now, that we have problems to respond where we don't have specific bilateral agreements. We need to move as a bloc to have these agreements done and concluded. And I am pledging here that if we conclude these, we should be able to do business a little bit quicker. I must hasten to say that we have had discussions with Kenya, Zambia, and Tanzania to conclude similar agreements we've had with Rwanda. It is my plea that once we go back to our respective capitals, we should try to convince our political masters to conclude on these arrangements. The issue of resources is a challenge, and as I said, we need to think around it. Our humble request or proposal would be that maybe as a grouping we should have a common fund where all members contribute, and that if there is any need to use those resources, they can be tapped in so that we can have a quicker way of handling our issues. The capacity challenges, they're there within our countries, and we need to address them. There are so many causes to these challenges, one of which is the movement of officers. The other one is that there's a language barrier. We need to have protocols which have been reduced to guiding tools so that within our respective countries, people can easily respond to the various requests which are coming through. The last challenge, which I think our colleagues from DRC alluded to, is a question of sincerity. It appears that some matters, the requesting country might have issues, or even the country which is looking to the request might have issues. So there is need to have a way of handling this. I can give you an example that currently we do have several matters which are stuck at this point because in one instance, a country is not willing to give up their national. In another instance, our country is not willing to give up their national. So by merely sitting on the request, it doesn't help. We need to come out and explain why we're still holding on to this so that maybe we can have progress. I believe my time is up. Thank you so much.
Thank you very much, DPP. He raises a matter. There is need to be cognizant of the economic and financial circumstances of the country to which you make a request. The question leaves with you, who meets the cost? But that's thought for all of you here as you continue with this conversation. Then we'll have our remarks from Zambia.
Good morning, everyone. I'm Mercy Pondamadilungu from the National Prosecution Authority of Zambia. In the interest of time, I'll start from slide number 5. Combating transnational organized crimes successfully demands international cooperation. One of the strategies we can use to fight transnational crimes is mutual legal assistance and extradition. This calls for considerable appreciation and observance of best practices for effective mutual legal assistance and extradition. And the effectiveness of mutual legal assistance and extradition also calls for national efforts by putting in place necessary measures. In our efforts to facilitate effective mutual legal assistance and extradition, Zambia has put in place relevant and responsive legislation aimed at enhancing mutual legal assistance and extradition. These laws include the following: the Mutual Legal Assistance in Criminal Matters Act, the Extradition Act, the Transfer of Convicted Persons Act, the Forfeiture of Proceeds of Crime Act, the Anti-Human Trafficking Act, and the Anti-Money Laundering Act. Zambia has also ratified applicable international and regional instruments, which include the following: the UN Convention Against Transnational Organized Crime, the UN Convention Against Illicit Trafficking Narcotic Drugs and Psychotropic Substances, the SADC Protocol on Mutual Legal Assistance in Criminal Matters, the Protocol on Extradition, and the SADC Protocol Against Corruption. Zambia has also gone further to enter into agreements with other countries in the region. For instance, extradition treaty with Rwanda, the extradition treaty with the Republic of Tanzania, the mutual legal assistance in criminal matters treaty with the Republic of Angola, and also the transfer of convicted persons treaty with the Republic of Angola. Other national efforts include the following. We have the Financial Crimes Court. We have also established the Financial Intelligence Center. We also have established the Asset Forfeiture Department and the Taxation and Financial Crimes Department in the National Prosecution Authority. These have dedicated personnel who handle such matters. We have also enhanced collaboration among institutions at national level. I'll give an example of the launch we had this year in January on the framework for interagency coordination in Zambia to enhance investigation and prosecution of asset recovery cases. Basically, this framework emphasizes on coordination and cooperation among internal agencies. The other efforts also include the involvement in international and regional associations, like we are a member of the Eaap. Such associations facilitate for opportunities to network and also exchange important contact details. The other efforts we are making is also the training of personnel. A number of members of staff from the Attorney General's chambers, the National Prosecution Authority, and other law enforcement agencies have been undergoing joint training programs aimed at building their capacity. Further, I can also state that we do have government support. There is political will and government support in the fight against corruption and transnational crimes. I have also given 2 practical cases that show our efforts in facilitating effective mutual legal assistance and extradition. And before I go into the brief facts of these cases, allow me to state that in Zambia, the central authority is the Attorney General's chambers. And the Attorney General can authorize other institutions or persons, including the DPP, to receive requests and act on them accordingly. So the first case is the case I've termed as the Horse Bay case. So in this particular case, there was a request from Namibia to the Director of Public Prosecution, Zambia, requesting to provide assistance in a case they were investigating on asset forfeiture. The request was made by the Namibian Inspector General of Police, who specifically requested for an affidavit outlining the Zambian legislation as regards an individual who has to export a certain amount of dollars. And in acting on this request, the Director of Public Prosecutions worked hand in hand with the Attorney General's chambers and indeed the Zambia Revenue Authority. So the lessons that we drew from this particular case were, 1, the expedience that is associated with administrative assistance, the need for requests to be specific, importance of both the requesting and the requested state to be aware of applicable laws and procedures, the importance of cooperation among countries' internal institutions. As you saw from this particular case, there was coordination between the Attorney General's chambers and the DPP, and also between the DPP and the Zambia Revenue Authority in helping Namibia with the request that they presented to us. The last lesson drawn from this particular case is the need for requested states to ensure that documents are in a format that is presentable in court. The other case I'll refer to is the case I've termed as the Patel case. In this particular case, there was a request for extradition, and in short, what basically happened in this matter is that the offenses that were indicated in the request and in the warrant, the external warrant of arrest, were different. So we had to send back the documents for them to indicate the proper offense, and the offense also that was indicated in the request. So there was this back and forth communication, which led to protracted processes in acting on this particular case. So the lessons that can be drawn from this particular case are the importance of attaching all relevant and necessary documents to the request, the need for both the requesting and requested state to ensure that documents are in order and are as accurate as possible before presenting them in court, and need for consultations between requesting and requested states. This now leads me to the challenges that are being faced in mutual legal assistance and extradition. The common challenges are as follows: submission of insufficient and inaccurate information, as has been given in the case that I have alluded to, failure to submit relevant supporting documents, communication barriers. This is mainly due to the use of different languages, differences in legal and procedural frameworks and extraditable offenses. Having different laws aimed at combating transnational crimes impacts negatively on the mutual legal assistance processes. The other challenges include bureaucracy in the process, which are time-consuming. The protracted processes associated with mutual legal assistance may lead to losing track of cases. Delayed responses. In certain instances, responses are received after subject matters have been disposed of. Resource issues and also technological needs. The rapid advancements in communication technologies demand for well-equipped institutions. I now go to plans for addressing challenges faced in mutual legal assistance. One of them is strengthening bilateral and multilateral efforts involving intergovernmental organizations such as the Interpol, promotion of regular bilateral and multilateral meetings that will assist in building networks and relationships. Effective mutual legal assistance requires well-trained personnel in applicable laws and practices. Therefore, there is need for developing more comprehensive understanding of how transnational crimes are perpetrated, and this should include regular training to combat the vice. The other plans are harmonization of legislation and procedures. I should state here that although total harmonization may not be achieved, ratification and domestication of international treaties may provide uniformity in legal frameworks to a certain extent. Development of memoranda of understanding between or among states with common interests to facilitate the cooperation outside the official obligations. These can be specific and responsive to certain needs. I'm being told that my time is up. Allow me to finish quickly. And also consistent political will in supporting effective instruments for international cooperation and for the provision of required resources. The minister yesterday emphasized on the need for the buy-in with the government. And in conclusion, I'll state that transnational crimes thrive on the different national legal systems and models of investigation and prosecution. There is therefore need for effective mutual legal assistance and extradition in combating transnational crimes. Nations need to make concerted efforts aimed at boosting international and regional cooperation. I thank you.
Thank you very much, Ms. Lunga. The communication I sent her was confidential. Then she said that time was up. But she raises the issue of combating international crime successfully demands international cooperation together with local political will. So that's a message from her. So, ladies and gentlemen, I have now entered into the session 4, and session 4 is supposed to be chaired by a different person. So I'm going to request that we have just 2 comments on the plenary, and there must be comments which have not been raised. So if it is a new issue, please put up your hand, we can share it, and then we can close this session. But if everything has been raised, that one we can also accept and move along. Okay, yes, please. Microphone at the back, please.
I'm Bettina Ambach, Director of Wayamo Foundation. I think one of the crucial issues here I'm listening to is it a bilateral agreement or multilateral agreement which can solve these challenges which everybody mentioned? And I just want to perhaps add something what the representative from Rwanda said. In the international world, and when it comes to trying to find an end to impunity for international crimes, you also have a new initiative which is called the MLA initiative. It's all, you find it online, and it's trying to find a new multilateral agreement on addressing all the international crimes which the representative from Rwanda has mentioned. And I think it's interesting to look at it and determine is it bilateral or is it multilateral, which may solve some of the issues. Thank you.
Any other comment, any other question? Rwanda, you need to prepare to deal with that question. Yes, DPP from Kenya. I almost gave away your, because when a person stood there, didn't introduce her, I said DPP is here. But thank you very much, Honorable Nordin.
Thank you, Honorable Chair. My question is probably a little bit provocative, in the sense that we have made our presentations and highlighted a lot of the challenges and experiences. But a lot of the experiences, if you look at, is hardly between ourselves. Most of the extradition requests come from elsewhere, especially maybe from the US or the UK. My experience has been that where the region is involved, we find it more conducive to requests for deportation through law enforcement, or in certain instances maybe easier ways instead of making MLA requests or going through extradition processes. It might be of importance for us, and the purpose of this forum anyway, is to see how best we can be able to work and get these processes done in a manner that will add value to the EAP. And maybe one way is for us to be able to decide what are our priorities when it comes to dealing with transnational crimes that involve the region. I just thought maybe I should be able to raise that instead of just for us giving prescriptive experiences and not trying to apply to how our relationships should be enhanced and built. Thank you.
Rwanda, the question was directed to you. Is it bilateral or multilateral? What solves our problem?
Thank you so much. When I raised the issue of the fight against impunity being universal, I wanted to draw your attention, all of us, to deal with transnational organized crime. It brings all of us on board to handle the matter as it is, with all the utmost, the necessity that we need to address it. So whether it is bilateral or multilateral, what the ultimate goal should be that we need to hold these criminals, we need to hold them responsible, we need to cooperate. So we know the issue of legal framework is very important. It is very important in a way that everyone has to base on it. So I would say multilateral would serve a purpose, but where we need to come to a conclusion that we can have a multilateral framework to address this issue, but where we lack multilateral, then we should engage country by country, which is bilateral. So to me, we need to have the same, the legal arsenal to address this issue. So to me, the issue of whether we should engage in bilateral, multilateral is not the point, but what should come to our point is that we should work as a bloc, as a region, or as a global world to address these issues. What we know, we have the UN Convention against transnational organized crimes, which most of the countries have domesticated and ratified. So what do we need? We need now to implement. So I would say already we have the laws as concluded by each state. You can see that we have legal frameworks, but how do we execute these legal frameworks and put them into practice? So we need these legal frameworks. This can be an open question to whoever is here. Not necessarily to me, but I give back to you, sir.
Thank you very much. My little experience, I've been Attorney General for hardly 2 years. One size fits all is a very dangerous way to go. I think we need to do both, multilateral, but take care of the unique circumstances of each and every state you interact with. I'd only allowed 2, but in every place there are people who are a little bit bigger than others. So since the President Eaap has put up his hand, I will allow him to speak. Thank you.
Thank you, Mr. Chairman. One quick comment. One of the concerns raised by many of the speakers is delay in execution of the request, and this is mainly done because some of the requesting state doesn't prepare their requests properly according to the laws of the requesting states. And this sometimes causes the request to be returned or rejected. Maybe one comment for me to my colleagues is to try to assist the requesting states by simple language. What are the requirements in your jurisdiction? In Tanzania, we have done that. We have prepared a guide for those who are requesting, and we have put it in our website. This simplifies the process. The requesting state knows exactly what is required when they are sending their request, and it reduced mistakes and errors. And when the request is received, we quickly execute it. So maybe may I use this opportunity to request my colleagues to try to prepare something very simple for the requesting states to understand what is required. Thank you, Mr. Chairman.
Thank you very much. And as I close this session, I would like to request members of EAP who are here that this session has been very informative. Don't lose it in resolutions. Get everything that has been put it together, and then resolve. When we share only resolutions, we lose a lot of what was said in the process. As I close, I leave you with these remarks. From Kenya, there is only one DPP, meaning follow the correct procedure. Don't send documents to the wrong person and hope to get a response. From Mozambique, communicate, at least acknowledge receipt of the request made. From Rwanda, The fight against impunity is universal. We are in it together. Crime knows no borders. From South Sudan, these are uncontrollable borders, or is it lines? We are one people, so remember that. United Republic of Tanzania, recognize the need for legislative reform to have an effective process, taking into account the practical realities. Consistently, as the times change your processes. From Burundi, the increased free movement of goods and processes exposes us to transnational crime. From the Democratic Republic of Congo, there is need for sincerity in the practice of MLA cooperation and the fight against transboundary crime. Let's not talk about it. Just talk about it. Let's be sincere about what we are doing. From Ethiopia, recognize the need to enter into treaties, agreements, and conventions on MLA. From Malawi, there is a need to be cognizant of the economic and financial circumstances of the country to which you make a request. The question it leaves with you is who meets this cost? Zambia, combating international organized crime successfully demands for international cooperation together with local political will. And as I close, the question posed to you by Honorable Nuruddin, I trust at the end of this session you shall answer it, reflect on it, and we are sure to get a good answer. I thank you very much for your participation here, and I hope we have learned as much as I have, and wish you great deliberations up till the end of this session. Thank you very much.
Please put your hands together again for the Honorable Attorney General. The Honorable Attorney General, we want to thank you very much. Personally, I knew you were going to do just great, like you always do. So I am not surprised, and you have really enriched our conference. That's why you did not see so many, the plenary was not very, there were not so many questions, because you were doing it as you went along, and now you also did the summary. Thank you so much. I would now like Manager of Programs to give us the next program.
Ladies and gentlemen.
Honorable members, with me here I have the Deputy Solicitor General, Mr. Pius Biribonoha, who needs to stand up so you can see him. He's at the back there. That is normally your point person in our office for MLA. So it is an important person. Before I give away the powers that have been entrusted to me, so while I still have them, that is the point person in our office. And we've tried to make it more accommodative in our office. We have people who are specifically handling MLA, so we hope that it will become much faster than it is. Thank you very much.
And ladies and gentlemen, let's give our Honorable Chair another round of applause. We couldn't have gotten a better chair for this session than him. And thank you, Chair, for bringing us Mr. Pius Biribonwa to follow up on the discussions that we have had. Let's also thank our presenters in a special way by also giving them a big round of applause. And also for our DPP for standing by our chair and keeping all the confidential communications. We have come to the end of this session. We are going to break for our tea and then resume within the next 15 minutes. But as we go for tea, we shall have a photo moment with our Honorable Attorney General. For a few of us, the executive members of the Eaap, the heads of prosecuting agencies present, and our development partners. The spot will be at the staircase downstairs as the rest of us go for our tea. I will also request our dear delegates, foreign delegates, who are sponsored, to please hand over your boarding passes to Madam Faith Analo. She's down there at the back. Please, Faith, stand up. And if you don't find her, you can leave them with me or with Lino Anguzu here. They will be in safe hands. Thank you so much. And we look forward to seeing you back shortly after the tea break.
Zambia, Kenya, and Tanzania. For us, we don't have the act in Uganda. We rely on bilateral agreements and conventions, but we are working on it. Yeah, I think it's important. Okay, have a nice break.
seats and resume. Go for our next session. Our next session is going to be chaired by the President of the Eaap, who is the DPP of Tanzania, Honorable Sylvester Mwachitakulu. Ladies and gentlemen, join me in inviting him to take up his seat. We have 3 presentations. We shall request the presenters to stick to the time allocated to them by the chair. So, Honorable Chair, please call up the members of the panel.
Good afternoon, delegates. I'm honored to moderate this 4th session, and we are going to have 3 presentations as stated by our MC. The first presentation will be on investigation and prosecution of terrorism cases, lessons learned from the 2010 bombing in Kampala. And our presenter will be Mr. Lino Anguzu. Mr. Anguzu is an Assistant Director of Public Prosecutions and Head of International Crimes Department in the Office of the Director of Public Prosecution, Uganda. He is a career prosecutor with vast experience in the prosecution of international crimes and terrorism cases. He has worked with the Office of the DPP, Uganda, for 18 years and is part of the senior management. Mr. Anguzu, you are welcome, and you have been allocated 20 minutes for you to make a presentation. Welcome.
Thank you, Chair and members, for giving me the opportunity to make this presentation. Usually I speak for about an hour when I'm talking about prosecution and investigation of terrorism cases, but I know I have only 20 minutes, so I am not going to run a PowerPoint. I will just speak from my notes so that I can keep your attention. As already introduced, my name is Anguzu Lino, and I am an assistant DPP. I work with the Office of the DPP here in Uganda. And I was involved in the prosecution, investigation, first of all, and prosecution of the 2010 Kampala bombings case. As you're aware, or for those who are not aware, on the 11th of July 2010, as the CJ gave you a brief yesterday, there were 2 simultaneous blasts in Kampala on an evening when revealers had gone out. It was the final ceremony of the FIFA World Cup. So people were out watching the game, merrymaking, and so these 2 blasts went off almost simultaneously at around 11 p.m. at night or in the evening, and so many people died. The confirmed fatalities were 76, but we anticipate that there were a little more. The others probably are not confirmed. And there were so many other injuries. As a result of that investigation into that incident, 15 people were prosecuted. Out of the 15, 10 were convicted, 2 on their own plea of guilt, and 5, of course, were acquitted by our honorable Chief Justice, who was a judge of the International Crimes Division, and then. So what did we what did we learn from the investigation and prosecution of that case? One, general observations. It was meticulously planned and organized. It was not a random act of terrorism. We learned that this thing had been planned for over 2 or 3 years before the final attacks. Training, recruitment, logistics, everything. So these guys were very organized. We also learned during the investigation that there was extensive use of information communication technology, mobile phones, emails, and everything. There was involvement or use of substantial financial resources, as the Chief Justice pointed out yesterday. I think it was discovered up to 35,000 US dollars, more than 35,000 US dollars, was used in the planning of that attack. It is unfortunate that we were unable to return a conviction on the part of financing or the chief financier. It's a disappointment, but that's what happens when you prosecute. Some you win, some you lose. This trial, the investigations at trial was very protracted. I think it took us more than 3 years to conclude the investigations in that case. So these are just general observations about the case generally. But here are the lessons. So I'll run through them very quickly so that I can keep within my time. And I was asked to make a few comments about the position of Uganda in terms of international cooperation in criminal matters, so that I can save some little time to make a comment about that. What did we learn? One, prosecute predicate offenses. They say a stitch in time saves 9. We did not prosecute predicate offenses in this case. 5 of the defendants who we eventually prosecuted had committed predicate offenses, had been arrested by law enforcement, both here in Uganda, in Rwanda, in Kenya, but no prosecution took place. We didn't know that all these predicate offenses were being committed in order to prepare for something which was bigger. So the lesson is all predicate offenses, please prosecute them. It may be a falsification of a document, it might be fraud, it might be illegal crossing of a border. That is all a predicate offense. So prosecute predicate offenses. I'll just give you an example of one person. Mugisha Mohamud was one of the defendants we prosecuted. Mugisha Mohamud had been arrested in Kenya. He was arrested on intelligence that he was facilitating Al-Shabaab. The Kenyan intelligence interviewed him. They didn't have enough to prosecute him, so they deported him to Uganda. And because he was in possession of Ugandan travel documents. So when they deported him, Ugandan immigration authorities took him. We interviewed him. We also didn't find anything. So we ended up prosecuting him for illegal possession of Ugandan travel documents, because eventually we found out he was Rwandese. So he was remanded in Luzira. Little did we know that he had been trained to be one of the suicide bombers in the Kampala bombings. He was actually coming to Kampala to execute the suicide bombing. And so he survived. And I think that is also what made us crack the case, because these guys were now short of personnel, so they had to do some haphazard recruitment of people who they didn't train very well. And these are the guys who made mistakes, and that is how I think the investigating team was able to follow them up and pick a lead and make the arrests. So prosecute predicate offenses. 2, involve prosecutions early in investigations in terrorism cases. Terrorism cases are very complex for very many reasons. 1, usually they're planned elsewhere and carried out elsewhere. 2, they're very secretive. 3, when a terrorism incident happens, the evidence is usually very voluminous. It is all over the place. So if you don't get guidance from prosecutors early enough, you end up making mistakes. In the 2010 case, again, we made mistakes. I think when it happened, we were still sleeping. So the police quickly woke up, followed the trails. I think even the first group of suspects we arrested was before the heavy involvement of prosecutors. And this was in Kenya. So eventually, by the time we came in, we found a lot of mistakes had been made here and there. But it taught us that it is important to involve prosecutors early in investigations to get guidance so that you don't make mistakes and lose evidence. Witness protection is very important in terms of investigations and prosecutions. Terrorism is usually committed by people who are prepared to be violent by the nature of it. So you can imagine no one is going to stick out their neck to provide you evidence or testify for you unless you can guarantee them some kind of protection. And it is good when this protection is rooted or anchored on the law so that any protective measures you accord them, it is guaranteed. We didn't have this in the 2010 case, so we improvised ad hoc protective measures. We had to ask the Honorable Chief Justice to allow us to conceal identity of certain witnesses. We use pseudonyms and so on. But this is dangerous because it can be questioned by the defense, assuming you provide financial assistance to a witness. That can be misunderstood by a court, or it can be argued by the defense otherwise. In Uganda, we have a case, it's not a terrorism case, but a case where the police provided assistance to a witness. They essentially provided her with some money to start a poultry farm. And so when she came to testify, the defense challenged her on the ground that she was testifying in exchange for the favor the police had extended to her. So it's important to put in place a witness protection measures, as ad hoc measures may not suffice. Be responsive to the concerns of victims, of witnesses. We had so many people who were injured in the 2010 case. Again, we didn't get it right. The president, I think, in that president made certain pronouncements about how some financial assistance was going to be extended to families of victims. Unfortunately, the process of verification was not properly handled. So border people who were victims of border accidents somehow ended up benefiting from that fund. And now that caused us a problem because when we were at the point of prosecution later on, some of the witnesses did not want to cooperate, some of the victims, because they said we didn't benefit from this, and we were left out. And so it was a big problem for us to explain that their participation is important for the case and that they should ignore what didn't happen well, but in order to prosecute the people who are alleged to have committed offense, their testimony was necessary. So it's very important to pay attention to their not only physical but emotional needs. We had witnesses who couldn't testify because they were terrified, they were traumatized by what happened, including police officers who responded to the scene. I recall this police officer who, up to the time when he testified, he couldn't eat meat anymore, beef anymore, because he was traumatized and he had not received any help, psychological help to treat him for the trauma. So it's very important to to be responsive to the concerns of victims of terrorist incidents, especially when they are very horrific, like the 2010. It is important, another point, probably lesson, is it is important to establish or have in place an enabling legal framework. We were lucky in 2010, we had the Anti-Terrorism Act. It was already enacted. And so we were able to prosecute the perpetrators for acts of terrorism. Imagine we didn't have that act. We probably would just have prosecuted them for illegal possession of firearms, maybe for murder. Now, that does not prosecute the full extent of the criminal conduct, because the extent of this, it was so extensive, linked to a non-terrorist organization, which is Al-Shabaab. The motive is political, to punish Uganda for involvement in AMISOM and intervening in Somalia. There's a lot of financing which was involved. There was a lot of planning and logistics which was involved. So you cannot effectively prosecute that conduct only by prosecuting murder, or for possessing explosives or something. So it is important to have a legal framework in place that allows you to prosecute cases like that. A legal framework, MLA, in order to bring in people from other jurisdictions who are incriminated. Also, domestically, have institutions, set up institutions in prosecution, in police, that are equipped to deal with these specialized crimes. In Uganda, we have the International Crimes Division of the High Court, which has jurisdiction to try terrorism cases. But in the office of the DPP, there is also a specialized department, the department that I head now, the International Crimes Department, which handles all cases with terrorism. In the police, I know it's a similar thing. So it's important to prepare and anticipate and have in place a legal framework that enables you to prosecute these cases. International judicial cooperation is absolutely necessary. This cannot be overemphasized. I think it is the reason why we are here today. It is the reason why this organization or association exists. We would not have succeeded if it was not for international judicial cooperation amongst our countries. And on that note, I would like to thank the DPP Kenya, the DPP Tanzania, delegation of Somalia, and our other neighbors, Rwanda, for the help they accorded us, because we eventually found out that the majority of the evidence we had in the case was actually in Kenya. Almost the entire evidence was in Kenya, and it was only the tail end which was in Uganda. And so international judicial cooperation is very important because of the so many reasons that have been elaborated already. It's a global village, technology, our porous borders, we are same people, and so many. So you'll find in the 2010 case, I think we had about 5 or 6 nationalities. There were Kenyans, there were Somalis, there were Ugandans, there were Rwandese, there were Tanzanians. I think there's one person who had dual citizenship. It was both British and Kenyan. So, and where did we get the arrests? We did arrests in Uganda, we did arrests in Kenya, we did arrests in Tanzania. Where did we get our evidence? We got our evidence from Kenya, we got our evidence from Somalia, we got evidence from Tanzania. We even got evidence from the US. Where did we analyze our evidence? We analyzed majority of evidence in the US. Where did we get our witnesses? We got our witnesses from the US, we got witnesses from Kenya, we got witnesses from Tanzania. I think there were 8 from the US, 4 from Tanzania, and 22 from Kenya. So it shows you that a lot of the criminal conduct actually took place in Kenya and not in Uganda. Uganda was a tail end. So judicial cooperation is very important, and some of it, as the DPP Kenya said, does not have to be formal. And maybe we need to ask ourselves whether we really need to, and the question he poses is valid, whether we should stick to formal cooperation only or we can do it informally. In the 2010 case, the first team, I think there were 4 accused, the defendants, the suspects. We arrested them in Nairobi. I think Nairobi, or I don't know, in Kenya. We had them. They were transferred to Uganda without going through an extradition process, a formal extradition process. That, of course, that matter was eventually argued, and so many things happened. But it assisted. I don't know what would have happened if we had to follow the formal process. Of course, later on, and then we got the others, we used the official channels. But sometimes you need to move very quickly. You can deport people because among the people in Kenya, we had Ugandans, so you can deport them. You don't have to wait for extradition requests and so on. So both formal and informal, we had our investigations. Kenya, we conducted joint interviews here. You'd have a team which had officers from Kenya Police, from Tanzania Police, from the FBI, from the US intelligence, from Uganda Police and all other agencies, so that you sit together and you can pose questions together. You all know what is happening. So international judicial cooperation is absolutely necessary. Evidence of cooperating witnesses and the use of plea negotiations and plea bargaining is very important in terrorism cases because of the nature of terrorism. It is a very sophisticated crime. They're very purposeful. It is usually rooted in ideology, and the people involved are radicalized, properly radicalized before they carry it out. There's training, it's based on loyalty, and the processes are designed to beat law enforcement detection and therefore prosecution. So you will never really understand what these terrorists have done or the processes they've gone through unless you get one of them cooperating with you. We were fortunate that about 3 or 4 of the people who were initially arrested, they cooperated. They provided vital information that allowed us to break the case, to follow up on others, and eventually prosecute. 2 of those, I think, eventually ended up pleading guilty. We negotiated with them, and they testified for us in the case. And their testimony was very important in explaining some of the things that we could not understand. For example, events that took place in Somalia, where there was no police officer, where nothing happened, events that took place in Kenya. So it's very important, and we have adopted it. Usually it is, you have to make a hard choice. It's a tough call, because one of the gentlemen who eventually we plea bargained with was the gentleman who pulled the trigger for the explosives in one of the places in Chadondo. And so we came under a little bit of criticism as to why we should have, because even then the judge, I think the judge sentenced him to 25 years imprisonment. There was a little bit of comment about that sentence, but it is the value of the information that he provided to law enforcement right from the time when he was arrested that probably was taken into account. This sentence was not negotiated by us. It was purely the judge's assessment of his involvement and his responsibility. And so, but the point I'm making is it's very important in terrorism cases because of the operations of terrorist organizations and the planning of terrorism. It is important to find insiders who are willing to cooperate with you. So you should always look out for that. And then have joint investigation teams. I've already talked about that. Technology. Focus on the use of technology. Look at the opportunity in technology, the opportunities it offers to solve. The breakthrough in this case came through the use of technology. It was a SIM card that eventually led to the discovery of how extensive the plot was, how far it extended. So we should look at the technology. It is a double-edged sword, but terrorists ultimately have to rely on using technology. The good thing is technology always leaves some trails. You just need to know how to find it. And the moment you find it, it can solve for you a case with mathematical precision, sometimes. In the 2010 case, what technology did we use? We used CDRs, telephone records. We knew where these guys were talking from, where they were located, which routes they used to pass when they were traveling. We knew which bills they had paid. Actually, the first arrest was made as a result of, I think it was a payment for power made to Kenya Power. It is the one that led us to the arrest of the first person. And this was used using a mobile phone. Emails, we were able to get some emails and know how these guys were communicating using emails, and they had a very interesting way of communicating. So what they would do is they would use drafts, and would never have understood it until one of them explained. So you would open one email address and share the password with all the people. One is in Uganda, another one is in Somalia, another one is Kenya, another one is in Tanzania. So if I wanted to communicate, I would open that and I would type my message and I would save it as a draft. I would never send it. And then the person in Kenya, I would find another way of communicating with the person in Kenya that I've sent an email. So in the sent emails, you will not see anything. But the person in Kenya would log in and open and read the draft and type a response and also save it as a draft. So that is why and we found the emails, so we knew what they were talking about, what they were saying. But it was important that one of them cooperated and told us this is how we do it. That is very important. So I will leave it at that. There are a lot of others, like protection for people who are involved, threats, and so on. I will leave it at that for now. We can take it further from there. I don't know, Chair, do I have one or more minutes, or am I out of time? Okay, I will leave it at that. I should have made other comments, but due to time, I think I will stop there. Thank you so much.
Thank you very much, Mr. Nguzu, for the very good presentation. I believe the delegates have learned something to assist them in investigation and the prosecution of this kind of cases. Maybe one thing to add, technology and financing. We have to do something to make sure that we investigate properly the financing of terrorism. Thank you. We'll have time for comments and questions later. May I use this time now to invite the other speakers? And the topic is international cooperation, investigation and prosecution of wildlife crimes. Here we have two presenters. You have also been allocated 20 minutes for both of you. I leave it to you to divide the 20 minutes. I may propose 10-10, but it is up to you.
I don't know if we are married.
Good afternoon. Thank you to this audience for giving wildlife trafficking a platform at this forum. The role of wildlife trafficking throughout throughout the world and its nexus to other transnational crimes are strongly be considered with the connections that exist and the various ties that exist. This morning I'm going to give you a brief introduction about who we are and what we are, and Steph then is going to talk to you about trends in the markets and ties to things. Then I'm going to come back on and talk about some of the investigative approaches that we utilize. So the slides aren't, oh, there we go. Thank you. If you go to the next slide, please. There's no clicker. Right here? Thank you. So, anyways, my name is Sean Carnes. I'm the Executive Director of the Wildlife Investigators Training Alliance. For 29 years of my life, I've been a wildlife criminal investigator, investigating trafficking cases with ties to all over the world. Along with that, my best friend and wife, Stephanie Durno Carnes, for 25 years of her life has been a wildlife officer and wildlife biologist. So between the two of us, we're around 55 years of experience in chasing bad guys. With that, we also have a team that's assembled of international trafficking experts that we use during our trainings as well as consulting with individuals. I must say that we've had the privilege since 2018 to train with. Please notice that I say to train with. We don't say we've trained this many. We've trained with over 2,200 rangers, investigators, prosecutors, and magistrates on the African continent. It's been an absolute privilege. The WIDA approach is we learn more from the participants in our classes, and we build upon that for future trainings. We don't come in and talk at the audience, we engage the audience. The training is immersive, and we believe that that's critical when considering international cooperation and furtherance of promoting best practices. Our approach focuses on value chains, value chain investigations. And we'll talk about that in a little bit. Also, I'd like to recognize that in this forum, we have departments of public prosecutions. So thank you for the amazing work that you do in prosecuting wildlife traffickers. Also, we have organizations, IFA represented. Yesterday we heard from Moses. They're doing phenomenal work all over the world. And for that, we are grateful. In addition to that, UNODC in your wildlife programs and the nexus with transnational crime. To collectively have these groups represented and for WIDA to be a part of that, we thank you. It's an honor for us to be here. I'm now going to ask Steph to come up and talk to you about various trade aspects, and then we'll get into the investigative approach shortly.
Thank you, and good afternoon, everyone. Just making sure where I'm at on our slides. And learning the remote real quick. There we go. I want to touch on very quickly that there really is a legal and a sustainable trade in wildlife that supports millions of people around the globe. And what we will talk about is distinct from that. Nearly $300 billion US dollars is traded globally, legally and sustainably. And it's fundamental to local, regional, and national cultures and economies. That being said, the illegal wildlife trade is entirely different. And the definition, just so that we are all on the same page, is the commerce of non-domesticated, so wild, animals or plants, We always think of the charismatic megafauna like the lion. It actually includes all plants and other natural resources, anything that's living or dead, and it's not only entire organisms, but also the parts and pieces and the derivatives. So at the very top right of this slide, you can see a dried bear gallbladder, and then a derivative of bear bile that's used in traditional Chinese medicine. So all of these are considered wildlife. And wildlife trafficking is anything that's in contravention of national or international law. And it comes in many different forms. We tend to think of it as poaching. That's the simple answer, right? And so many poor people rely on poaching for sustenance. How could we possibly be prosecuting this? That's not what we're talking about right now. The bush meat trade is no longer about subsistence hunting. It is about a status symbol in developing countries. It is about a delicacy or an exotic dish. Bushmeat trade that's harming wildlife is just as critical as the other components of illegal wildlife trade: smuggling, outright poaching, the capture of live animals for the pet trade. And it also includes things like money laundering, false documents, and fraud. And unfortunately, as with every crime, corruption is rampant. Bribery is common, especially used to secure permits and allow for transnational transportation. And it's often included as part of the legal wildlife trade that we've talked about. The demand, the bushmeat. Ingredients for traditional Chinese medicine are critical in the illegal wildlife trade, and it's the demand for those kind of products that continues to fuel it. Jewelry and trinkets, we all know ivory is turned into valuable decorative items. Trinkets, jewelry and furs, and always trophies, hunting trophies. Here in the bottom right of this slide is a traditional Chinese medicine shop in rural Malawi, selling traditional Chinese medicine in rural Malawi. And the trade is everywhere. This slide is a bit difficult to see, and I apologize for that. It's just a bit washed out. But this is from C4 Ads, and it shows the convergence of wildlife trafficking with other crimes. So the red routes are seizures of convergent crimes. So something has been seized en route with wildlife parts. The blue lines are wildlife trafficking only seizures. You can see from these slides that the crimes are really converging. In the past, generally, wildlife traffickers frequently specialized, and they frequently specialized in species or in geographical areas. But now they are converging with other crimes like drugs and human trafficking. And the astonishing thing is that across this, when we think of it as a global problem, it really is true that there are, of these seizures, representatives from 100 different countries are included in these seizures, and not more than 9% of any species makes up for any of these seizures. So when we think of those charismatic megafauna like elephants and ivory, or even the charismatic minifauna like pangolin, they are not in the bulk of the trafficking that's going on. It truly is universal. And the impacts of illegal wildlife trafficking are astonishing. And wildlife crime has often been thought of as a minor crime and as a victimless crime. And that is not true. Every single person in this room, every single person listening is a victim of illegal wildlife trafficking. It's estimated that certain countries in sub-Saharan Africa lose 6% of their GDP to the illegal financial outflows as a result of forestry and fisheries trafficking alone. That's not to mention all of the other trade that I've talked about related to illegal wildlife trafficking. The impacts of illegal wildlife trafficking also contribute to climate change and obviously the decline of biodiversity. In addition, 75% of emerging human diseases are likely to be attributed to wildlife, zoonotic diseases. We all know that. It's very close to home here, but I know I don't want to go back into lockdown as just a simple example of the impact that zoonotic diseases can have on us, not to mention the many other diseases that we all know and that impact really, truly Africa disproportionately. And degradation of community structure. How many of you in this room can think of a family or tribal or cultural tradition that you hold dear that's associated with wildlife? I know my family, my culture has traditions, stories, and cultural practices that are associated with wildlife. When those species disappear, we lose our cultural heritage as well. And unfortunately, IWT persists. I'm not nervous, I'm just clumsy. It's better to just admit it, right? So thank you for your patience. So IWT persists for a variety of reasons. The biggest is that these transnational crime syndicates that are fueling arms trafficking, human trafficking, drug trafficking, they are also the ones that are funding wildlife trafficking. So the resources that are available to us who are combating wildlife trafficking are incredibly unequal. Every time we start to catch up at one of their new techniques, they have the resources to make another leap ahead of us. That perception of a low priority and victimless crime, it's incumbent upon us to change that perception. There's a surging demand as economies across the world are developing and increasing in buying power. These wildlife products are a sign of status. In addition to that, I'm a wildlife biologist, but I'm not positive, but I would not be surprised if I'm the only one in this room. The biological considerations for wildlife are so much more complex than, say, for a drug offense. It's so easy to hide behind the legal wildlife trade because you have species that may be endangered in one country and not in another. Species look very similar, and the derivatives, the parts, and the pieces are so complex. And that feeds into the conflicting regulations at the international and even regional and local level. And so all of this creates a realm of confusion and ignorance that just fuels the perception of it as a low priority and victimless crime. And corruption, unfortunately, is rampant. UNODC, who we rely on for outstanding research, notes that less than 10% of the corruption in wildlife trafficking crimes has been attributed to either officers or investigators. This is really good news. Those who are directly mandated with protecting our natural resources are the ones who are least likely to be corrupted in wildlife trafficking. However, the corruption that is seen is in so many different levels, customs and revenue and transportation. It's difficult to educate, and so it continues to fuel itself. Now, the big question you're all thinking, other than when is lunch and will she ever stop talking, is what does this have to do with women and children? Why does this matter? And surprisingly, it impacts women and children far more dramatically than it does men. We all know that women and children, as we've talked about throughout this workshop, women and children are disproportionately affected by climate change and loss of biodiversity. And IWT is frequently looked at as either a gender neutral, gender blind, or a gender biased perspective. It's all men doing it, or that it doesn't have differential impacts, and neither is true. But there is not much information that's known about the roles of women and children in wildlife trafficking. There's a substantial amount of research that needs to be done, and there are great resources that are coming out. I'm not going to talk about the breadth of information that is being discovered right now and just recently published. But as we all know, the impacts from wildlife trafficking are economic, and women and children are generally at the lower levels of the wildlife trafficking syndicates. And so the proceeds from wildlife trafficking are enjoyed by the men that are frequently at the top of the syndicates running the networks, where the women are more likely to be at the lower level and affected more closely by the economic harms. With that, I'll turn it over to my husband for his wrap-up on investigation techniques.
I'm so lucky to have her on my team. She's the smart one in the family, by the way. So, with regards to wildlife trafficking in the approach, we know we have multiple players. Just as with any other form of crime, whether it's human trafficking, narcotics, arms, there's various levels of involvement. So even going back several years ago, I spent 4 years of my life undercover with Russian organized crime figures. We were dealing in wildlife. Wildlife was the primary commodity. We had a meeting with basically a leader of a group, so to speak, a godfather. And during this meeting, there were numerous young women from the former Soviet bloc countries that were dancing on a stage. They offered them to us. It was tragic. It was disgusting. Here I went in there from the perspective of purely wildlife. By the time we walked out, we had information about arms trafficking, human trafficking, smuggling, and all sorts of other crimes. There is a definite nexus that exists. So with this approach, sake of international cooperation, when we're training people to examine the value chain, we train them to enter the value chain at any level with any information that they have available to them. The value chain, they can work up, they can work down. Ultimately, the goal is to get to the head of the snake, to identify those behind it. So what we talk to people about is the most effective tool. We want to get into the heads of the bad guy. As I said, we train with. We don't just train. So we train the investigators, the prosecutors, to get in the head of the bad guy. When we can understand motive, we can more effectively investigate and prosecute offenses. We have to understand their motive, what motivates them. The wildlife trafficker, of course, is motivated by profit. If you look at this whole stream of players, it focuses around money. So we train in following the money. We looked at connecting the dots. The gentleman that spoke before us talked about the value of digital evidence. And the value of digital evidence that exists goes back to a time-honored principle that started with original crime scene work, Edmund Locard's exchange principle. In forensic science, his principle holds that the perpetrator of a crime will always bring something into the crime scene and leave something behind when they go from it. We all walked into this room today. We left a trail of our presence. We're all connecting to Wi-Fi. we're leaving breadcrumbs. We connect to cell towers, we make calls, we place emails. So what we encourage for best practices, especially international cooperation, is to utilize various tools to follow the money, to establish organizations, determine hierarchy within organizations, and we look at patterns of criminal behavior. Human element. How do humans respond? We all, as human beings, in times of crisis especially, or when we think that the law is on us, we tend to revert back to normal patterns of human behavior. This also applies to all forms of trafficking, wildlife, or any crime whatsoever. So we utilize these different tools that are on the screen, and I won't get into them too much for time's sake. But I want to hit on cellular evidence. Cellular evidence has been vital, both from tower connectivity as well as to digital device forensics. This is one thing that has been absolutely monumental for investigations that I've participated in the past several years. It's WIDA's goal to put this technology in the hands of every group that we train with throughout the African continent. So we train in these aspects. We cross-train in different areas, and also we train with prosecutors and investigators together in the same room to encourage prosecutor-led investigations. When we take a group of investigators and we put them on surveillance and we have prosecutors with them, the prosecutors can now begin to see through the eyes of the investigator. When we begin to prepare and assemble this investigation for presentation at the end, after they've done undercover work, after they've done crime scene work, the investigators and prosecutors work collaboratively on that. Then ultimately, when it's time to present that case, the investigators have the perspective of what the prosecutors are going through and what the prosecutors demand. This is effective. It works. Must also realize with the value chain that exists with traffickers, there's a criminal justice value chain in wildlife trafficking. It starts at the ranger or a wildlife police officer. They need to be encouraged and empowered. They need to feel important and necessary as their role is. They are the initial eyes and ears on the ground. The investigator, prosecutor, judges, and magistrates need to be familiar with all aspects of this chain. When the criminal justice value chain breaks with one link, it is no longer a chain. Therefore, the bad guys win. So we encourage the utilization of innovative techniques and tools. This slide here, we get a lot of feedback from people that we have trained. They no longer look at, there's a saying, one in hand. We've caught one, we're good, let's go home for the day. We encourage looking to the next level, looking at the network, looking at the potential that exists. The individual in this picture that was apprehended selling ivory, obviously something put that in his mind. What drove him to go there? Money. Money. So with that, we're going to look at a recent collaboration which we had the privilege to participate in Uganda here. We completed a 5-day advanced wildlife crime investigative course. What strengthens international cooperation? Collaboration. Collaboration, we heard yesterday, it takes a network to take down a network. And that is true. But I would like to add one thing to it, and I want to attribute to a dear friend of ours, Vincent Opini. Some of you may know him in Uganda here with Natural Resources Conservation Network. It takes a trusted network to take down a trafficking network. When we're all on the same page and on the same team and trust each other, therefore we become more effective. When we utilize the same tools, we become more effective. When we speak the same language, we become more effective.
The last thing I will talk about is putting our money where our mouth is. So we encourage the development and also the ongoing stewardship and mentoring of the investigators, the prosecutors, the wildlife police officers that are on the front lines doing the work to combat international wildlife trafficking. And this will ultimately elevate, well, that's not good. It was such a good picture. There we go. Okay. It will elevate the ability of these teams to detect, investigate, prosecute, adjudicate, but ultimately deter wildlife crime. And we recommend that we provide a network of experienced, highly trained, and dedicated wildlife law enforcement and prosecution personnel who can educate and mentor people in their own country. And having an international network of these leaders who fight wildlife crime that can then share their knowledge, their experience, their connections in their own home countries is absolutely critical long-term to fighting wildlife crime. And we have to train them and equip them and mentor them long-term to do this work. And I don't mean just anti-poaching patrols. Anti-poaching patrols have value, but we need professionals who are trained to do investigations, who can be participants in their communities, and who can encourage their communities to look for novel ways to create economic opportunities that are not just based on poaching, that return the intrinsic value of wildlife back from just a simple economic value. And we need to do this by showing that they are valued, by investing in their training and giving them the basic training like self-defense, like first aid training, the equipment to save their lives or poachers' lives when they are on patrol and actually fighting the wildlife crime, but also investing in their professional development so that they understand why they're doing it, so that they have the connections to better build relationships and collaborate internationally on fighting wildlife crime. And we have to show that we value them and the work that they're doing, because it is incredibly dangerous and it's incredibly important. And I hope that we've shown you not only the value of wildlife, but also the impacts of wildlife trafficking. And what I hope you go away with is that investing in our rangers, in our wildlife police officers, in our prosecutors, in those who are fighting wildlife trafficking on the front lines is really what we need to be doing to stop wildlife trafficking. And this is one of my favorite quotes. I'm not very eloquent, especially when there's so many people looking at me. So I often rely on good quotes to share thoughts of mine, and this is one of my favorites. This is from Baba Dome. I'm sure I've pronounced it incorrectly, but he's a forester from Senegal. And he said, in the end, we will conserve only what we love. We will love only what we understand. And we will understand only what we are taught. And so hopefully you've learned a little bit about the value of wildlife and what we can do to protect it, and I encourage you to share it. I've loved wildlife. Sean and I have both worked in wildlife law enforcement and conservation our entire careers. And the first time that I was asked to talk about the intrinsic value of wildlife, I had no words. It was just something I've always known in my heart. And so learning how to articulate the value of wildlife and how to share that and give it to other people is really critical as well. So I hope that we've given you some information that will help breed the next generation of wildlife conservationists. And now, I'm done. It won't advance, so it's clearly time for lunch. Thank you for your patience, and thank you for this opportunity to speak with you.
Thank you very much, Mr. and Mrs. Carnes, for your cooperation and the collaboration in making the presentation. I commend you. Dear delegates, I believe we all agree that wildlife trade is one of the concerns in many of our Eastern African countries because it fuels other offenses, other crimes, illegal human trafficking, drug trafficking, corruptions. So we must join hands in fighting these crimes. And we should not only investigate and prosecute the crimes, but as presented by Sean, we should conduct parallel investigation, financial investigation, to follow the money, to follow each and everything which is a proceed of this crime. Thank you very much. So 5 minutes for comments and questions, if any, before we break for the next session. You're welcome. Yes, I've seen one hand somewhere. But if there is no comment, then I adjourn the session. Thank you very much, my presenters. Thank you, sir. So we'll be breaking for a few minutes to allow the executive committee to meet, and thereafter we'll resume for the resolutions of the conference and our meeting. Thank you.
Thank you, Chair. Ladies and gentlemen, let's put our hands together for the chairperson for this session. Thank you so much, Your Excellency. And another round of applause to our presenters. At this point, we are going to break for a session. The rest of us will go for lunch, early lunch, as the executive committee breaks for a closed session. For avoidance of doubt, the executive committee comprises Tanzania, Uganda, Kenya, Rwanda, and South Sudan. They will have a closed session for about 40 minutes and then also go for their lunch. After our lunch, there will be the AGM, which will be attended by the heads of prosecution agencies present. It will also be closed door. The rest of us, we shall continue with our lunch. And then resume for the resolutions at We shall resume at 4 for the resolutions of the conference and declarations. And then the closing ceremony will immediately take place. And then we shall break for the tea at the end and prepare for the dinner in the evening. Thank you so much. So at this moment, the Secretariat is going to coordinate those two events. And then the rest of us, we shall come back here at 4. I hope everyone has got a coupon. Lunch is in the usual place where it was served yesterday. So we can go down for lunch as the Secretariat takes charge of the next 2 meetings. Thank you so much. Members, the rest of us, much as our lunch is going to be extended, don't be tempted to change into beach wear. Let's remain formal for the closing ceremony as we return at 4 p.m. Thank you so much.
Members, if you're not a member of the executive committee, can we please exit the hall? Because the executive committee is going to use this hall. So we need to leave them, the secretariat, time to organize and prepare. So the rest of us, can we please leave the hall and go for lunch until 4 p.m. when we will reassemble here. these guys are meeting here. Colleagues, let's exit the hall, please. Those of us who are not members of the Governing Council. Executive Committee. If you're not a member of the Eaap Executive Committee, please let's exit the hall right now.
because you are still a signatory to our accounts. And we were discussing and saying the balance is reducing. How do we do it? So that's why we took long. Let me also invite to come on the podium, on the high table, the outgoing president of Eaap, DPP Tanzania, and the incoming president, DPP Kenya, Aji. Please join our guest. Thank you so much. My Lord, Justice Mike Chubita, Justice of the Supreme Court of Uganda, my Lord, the incoming President of Eaap, not my Lord. I saw you smiling, it's not. Honorable Mr. Sylvester Mwakitalu, outgoing President, Eaap, distinguished ladies and gentlemen. My Lord Justice Mike Chubita, before you both international and national delegates and development partners. The national delegates are from 11 African countries. And I'm sure most of them, you do not know them. You see the faces are all young. Most of the DPPs are new in office. I think the baby is from Malawi. He's just about 2 weeks old in the office. We have prosecutor generals, we have attorney generals, and they have come with delegations ranging from 3 to 8 delegates. And we also have the local delegates, mostly from the office of the DPP, you know all of them. And we have the development partners, whom you know most of them. We have IJM still here. Madam Wamaitha is right there. I'm sure you still remember her. We know there's Bettina, and I think I still saw Mr. Olinga of IFAW, perfect. So we have our development partners here as well. My Lord, without, and the press, of course, without taking so much time, I would like to invite the incoming president, I think. The outgoing. I would like to invite, I've already discarded him, I'm so sorry. I would like to invite the outgoing president to give us a few remarks before we can invite His Lordship, Justice Mike Chubita, to close our conference.
Your Lordship, Justice Mike Chibita, my late Justice Jenny Abodo, DPP of Uganda, my brother Honorable Nurdin Aj, DPP Kenya, my colleagues, Director of Public Prosecutions and Prosecutor Generals, members of the technical committees, I just want to be very, very brief. As an outgoing president of the East African Association of Prosecutors, mine is only to thank you. I thank my fellow members of the Executive Committee and all member states for the cooperation you have shown to me as a president in the past years. I've been the long-serving president of this association. According to our constitution, before we adopted the new one today, elections should have done annually. But I've been president for more than 4 consecutive years, and you have shown cooperation to me. I really thank you very much. And I also ask you members, I beg you also to support the new executive committee, to support the coming president. This will enable us to achieve the goals, the objectives of our associations. With that few remarks, I thank you very much.
Thank you so much, DPP Tanzania. I now want to call DPP Kenya to give his remarks.
Thank you. My Lord, Honorable Justice Mike Chibita, Justice of the Supreme Court of Uganda, Honorable Lady Justice Jane Francis Abodo, Director of Public Prosecutions, Republic of Uganda, and the incoming Secretary General, Honorable Sylvester Anthony Mwakitalo, the East African Association of Prosecutors outgoing President, the Director of Public Prosecutions of Tanzania, Honorable Deng Adija, Director of Public Prosecutions of the Republic of South Sudan, Honorable Sylvester Nyandwi, Prosecutor General of the Republic of Burundi, Honorable Famin Monde Mambu, Prosecutor General of the Democratic Republic of Congo, and one of the incoming Vice Presidents of the EAAP, Honorable Masauko Chamkakala, Director of Public Prosecutions of the Republic of Malawi, Honorable Gilbert Firi, Director of Public Prosecutions of the Republic of Zambia, Honorable Suleiman Mohammed Mahmoud, Attorney General of the Federal Republic of Somalia, Honorable Government Representatives, Development Partners, distinguished colleagues, good evening. First of all, I want to assure you that there was democratic elections and we really voted and these are the results, so no rigging. I'm deeply honored, and I think there will be no appeals or election petitions. I'm deeply honored and humbled to stand before you today as the newly elected president of the Eastern Africa Association of Prosecutors. My heartfelt gratitude to each and every one of you for placing your trust in me and giving me this incredible opportunity to steer the association towards realizing our common vision of enhanced regional cooperation in preventing and combating transnational organized crime. I would like to take a moment to thank the outgoing administration under the stewardship of Honorable Sylvester Mwakitalo, DPP Tanzania, for his transformational leadership and being at the helm for the last 4 years. your administration reinvigorated our effort in the execution of our objectives and bolstering cooperation not only in East Africa, but also in both Southern and Central Africa, respectively. It is therefore my hope that we will build our legacy. We will build on your legacy. The unique opportunity to serve as the president of the association is a responsibility I will duly undertake to ensure that the objectives of the association are met. As the EAAP potential grows, I affirm my commitment to strengthening regional cooperation through the following initiatives. Firstly, in recognition of the importance of the association's ability to achieve autonomy in its decision-making, it is therefore critical that we strengthen our membership. In this regard, I propose that we open the association to individual prosecutors across the region, where individual prosecutors may voluntarily register as individual members of the association and will be subject to nominal payments. I believe this will significantly bolster our efforts to strengthen our financial independence. Secondly, I call upon us to integrate rapid advancements in technology within our operations. As the world around us continues to change as a result of these advancements, so must we. Through digitization, we can streamline our processes and procedures as a region and enhance our research and development capacities, as well as aid in the adoption of data-driven strategies and policies. Thirdly, as we integrate our efforts as the national prosecution authorities, I believe that we must enhance joint capacity building and training exercises with a view of developing wealth of expertise on different thematic areas across our respective jurisdictions. Fourthly, I recognize that our efforts in effective cooperation are significantly hampered by our differing legislative structures. It is therefore high time for us as Eastern African Association of Prosecutors to explore avenues that will allow for hybrid legal systems and or processes to support our efforts in combating crimes. I firmly believe that this approach, however novel, will represent a significant step towards transforming our legal system as a regional association. Finally, I have further noted from our deliberations the call for robust information sharing networks through a digitized platform. I therefore pledge to engage our member states and partners towards realizing this platform. Colleagues, I urge us all to leverage on engagement opportunities such as this conference as a means to build networks and trust within our association. And I must once more congratulate the DPP Uganda for successfully organizing this conference. As we move forward, it is my hope that I will be a beneficiary of your support, as together we can overcome any obstacle that may arise. It is my intention to be guided by the highest standards of professionalism towards the realization of quality and enhanced prosecution services in the region. Together, we can make a difference in the lives of those we serve. Thank you again for your confidence in me, and I look forward to working with each and every one of you in the days ahead. I also wish to thank Justice Chibita, who was our former president. I remember when we were in Mombasa, after the COVID, we asked Tanzania to continue. So little did we know 4 years down the line, then we will be in Kampala with him, now as Justice. I think I want to thank you for being patient with us, even though we delayed you, and for finding time to be with us. One encouraging thing is I can see he looks much younger, far much younger than when he was DPP, and more comfortable and relaxed, which is something that gives us all joy. Thank you, and God bless you, and welcome back to the DPP Prosecutors Forum. Thank you, sir.
Thank you so much, Mr. President, DPP Kenya. I would like once again to thank the Honorable Justice Mike Chibita for honoring our invitation to come and close this conference. And we also want to apologize for keeping you for more than 1 hour, but you still came and you're still smiling in the room. So I want to take this opportunity and with all humility to invite you to give us your remarks, and then you close this conference. But before you close it, you symbolically have to hand over the Constitution to our incoming president, which is in 3 languages: English, Portuguese, and French. Thank you. Thank you very much, DPP Uganda. Thank you very much, our outgoing president. And thank you very much, incoming president. Okay. The Honorable the Attorney General of Somalia, the Honorable the Deputy Attorney General of Mozambique, Director of Public Prosecution, Uganda, who is also the hostess and the Vice President of the East African Association of Prosecutors. In case I make a mistake, this is a protocol lineup I was given. I don't take responsibility for it. Director Public Prosecutions, Tanzania, and also I now know outgoing president of the association. Director Public Prosecutions, Kenya, now outgoing, incoming president. Prosecutor General Burundi, Prosecutor General Democratic Republic of the Congo, Director of Public Prosecutions, South Sudan, Director of Public Prosecutions, Zambia, Director of Public Prosecutions, Malawi, Head of the Federal Public Prosecutors Administration Council, Ethiopia, Representative of the Prosecutor General of Rwanda, Regional Representative of Eastern Africa, UNODC, Country Director, UNODC, Country Director, International Justice Mission, Country Director, Human Trafficking Institute, Senior Technical Advisor, AML, CFT, Program Director, AGA, Program Manager, FAW, International Director, WAYAMO, prosecutors gathered here, distinguished dignitaries in all your respective capacities. Ladies and gentlemen, that was quite a mouthful of protocol lineup. Glad I'm out of it alive. But it gives me almost goose pimples to be back here with, can I say, fellow prosecutors? Because 10 years ago, when I was appointed DPP, I was being welcomed to the office by a smaller East African Association of Prosecutors. And I remember very well Ndugu Tobiko, whom our brother Haji replaced, welcoming me and teaching me the ropes. And also Ndugu Feleshi, now Attorney General of Tanzania. The two of them welcoming me and showing me around. But we were 5 countries then. Rwanda and Burundi had just joined, and Southern Sudan was joining. It is testament of the resilience of the association, and especially the directors of public prosecutions of the founding countries, that the association has now grown to 11 countries. I would like to congratulate you all on that growth. And this high-level conference on transboundary crime, practical approaches to protecting women and children, is coming to a conclusion today.
It is our great honor as a country to have spent the past 3 days with friends from different countries. With your participation, the conference has successfully finished all its sessions. I am reliably informed. And on behalf of the government of Uganda, I would like to extend our highest reverence and most sincere gratitude to the joint efforts of all the participating leaders, experts, guests, and representatives, and our most cordial congratulations to the success of this high-level conference on transboundary crime. Thank you very much and congratulations. As the conference ends, I believe we all have the same sentiment that women and children are persistently pursuing the dream of living in a crime-free society where they would enjoy their rights and freedoms. Throughout these 3 days, we have seen the possibility of their dreams becoming reality. Says Joyce Hilda Banda, former president of Malawi, is quoted to have said, and I quote, "The seeds of success of every nation on earth are planted in women and children," close quotation. Dear friends, we all know the importance of seeds. In their absence, we cannot have new plants. A society or nation is not just land and infrastructure. It is a living thing. Human beings are its lifeblood. As deliberated upon in this conference, the most important component of society are the women and children. I think even women agree on that. When we fail to protect them against transboundary crime, then we would be destroying future generations and would be a failed generation. Let us pause for a minute. To whom shall we hand over this society if women and children are threatened by transboundary crime? No country on earth is an isolated island. It is therefore necessary for cooperation, collaboration, and communication in investigating and prosecuting transboundary crime. In this globalized world where information technology, criminality, among others, are evolving at an unprecedented speed, this places significant pressure on the law enforcement agencies. There are other challenges such as surging population, unemployment and underemployment, poverty, financial crisis, climate change, energy and food security, which have all posed threats to women and children's dream of a decent, crime-free life. Transboundary crimes such as human trafficking, terrorism, sexual and gender-based violence, wildlife crime, money laundering, all these have been and will always be a challenge for countries of who we are representing today. We are called upon under the leadership of the East African Association of Prosecutors to strengthen our cooperation, extend our communication, and establish collaborative relationships so as to establish an effective investigative and prosecutorial framework in tackling transboundary crime. During the 3 days meeting, you had in-depth discussions and communications on 7 major topics: understanding sexual and gender-based violence, gaps and the way forward, international cooperation, investigations and prosecution of wildlife crime, presentation on child sacrifice, trafficking in persons, strengthening regional cooperation in Eastern Africa, technical working group on trafficking, Red Tram, the South American experience, the importance of interagency cooperation in ensuring timely prosecution of transnational crime, harnessing international cooperation to combat transnational crime in East Africa and beyond, presentation on the importance of the domestic application of the criminal law, investigation and prosecution of terrorism cases, lessons learned from the 2010 bombings in Kampala, and last but not least, presentation on anti-money laundering and terrorism financing. You not only analyze the general situation and existing problems of the need to protect women and children against transboundary crime, and introduced advanced experiences from home and abroad, exchanged ideas on progressive theories and major practices on protection of women and children against sexual violence, tackling human trafficking, child sacrifice, international cooperation on criminal matters, terrorism, and effective criminal investigations. These discussions made this high-level conference on transboundary crime, practical approaches to protecting women and children, a wonderful exchange of ideas and provocative thoughts. Guests and representatives here have shown amazing wisdom on the benefits of international cooperation in criminal matters and effective intervention for protecting women and children against transboundary crime. Therefore, I firmly believe that the closing of this conference is not an end, but a beginning. As Mr. Rajnath Singh, the Minister of Defense for India, rightly concluded that, and I quote, "Safety and security of women and children will determine the well-being and strength of our nations." Close quotation. Let us therefore build on our current position and look ahead into the future and strengthen the initiatives of the East African Association of Prosecutors so that our women and children are effectively protected against transboundary crime. Dear friends, please allow me, on behalf of the government of Uganda, to express once again our sincere gratitude for the support and the decision by the East African Association of Prosecutors to give Uganda this opportunity to host this high-level conference on transboundary crime, practical approaches to protecting women and children, and for the participation of all parties. An African saying goes, and I quote, "Even the best dancer leaves the stage." Close quotation. All good things and bad things come to an end. I hope that this high-level conference on transboundary crime, practical approaches to protecting women and children, held here at Speak Resort, Munyonyo, Kampala, will have a memorable impression on all the participants and guests. I hope that all experts, development partners, and prosecutors present at this conference can enhance friendships and strengthen cooperation so that we can make joint efforts in pushing forward the effective protection of women and girls against transboundary crime. We also sincerely hope that all the distinguished guests here can explore the unique attraction of Kampala during the field trip that has been organized for you. Here we have traditional culture, exquisite life, and graceful living environment. I'm sure that once you come to the Pearl of Africa, you will forever love it. We look forward to meeting you again in this historic city of Kampala soon. One of the anecdotes I had from a visitor to Kampala was that one of their lasting memories of Kampala was that they were able to buy roasted maize from the streets of Kampala at midnight. One of the unique things in Kampala is that the city almost never closes down. And somebody was wondering why. And I was trying to give a historic perspective that when we were growing up, going to school, there was somebody called Eaap here. And they would impose curfew. You were not to go outside anywhere after 6 p.m. and not get into the streets until 6 a.m. So many of us, our generation, grew up being indoors. So when curfews were removed, we are still recovering and saying, are we sure we can go out at night? And then we go out at night. And before we know it, it is morning. So I hope you experience that life of Kampala. I was about to call it the nightlife, but that might be misunderstood. But the life at night in Kampala. Thank you all. Asante sana, merci beaucoup, obrigado, murakoze chane, ameseginalehu, mwebale nyo, mwebalire dala, for God and my country. With those few remarks, I would like to declare this conference on transboundary crime, practical approaches to protecting women and children closed. Thank you.
Another round of applause for Honorable Justice Mike Chibita. Thank you so much for bringing this eventful conference to an end. And I don't want to spoil the ending. As I see out Justice Mike Chibita, I want you now, since the conference has been closed, I want you just to now go over the resolutions. And then please don't forget to give the program for tomorrow. Thank you so much. Thank you, everyone. Thank you.
Friends, I think we also need to give ourselves a round of applause for being such a wonderful audience and for the patience, and congratulate ourselves for coming this far. As we wait for the resolutions, I think the Secretariat will lead us in that. Let me make these few announcements. Justice Mike Chibita has talked about not the nightlife, but the life in Kampala at night. So for those of you who may wish to go and see that life tonight, our foreign delegates, you all have protocol officers. Please consult them and make your intention known. They will be at hand. There will be tea at the end of the resolutions. Tea is ready at the usual place at the balcony. So let's not leave it behind. Dinner coupons will be served by the hotel front desk. So as we leave this hall, please make sure you have your coupon for dinner tonight. Tomorrow's program will start with the breakfast, which will be served in the usual restaurant from 6 up to 9. And then we shall all converge at the reception. There will be buses to take us for the city tour of Kampala. This is for our foreign delegates. The tour, we shall see several places. There is a detailed program which will be shared, and it will take us the whole day. We shall have a lunch break within the city, continue with the tour, and then return to the hotel by 4 p.m. to refresh and prepare for the farewell dinner and entertainment. So that we show you some of our cultures and some of our... it's time to unwind. Please, the dress code for the outing will be free dress, free style. The weather is changing a bit. It's not as hot as it were. And I think we attribute that to the blessing that you came with. Kampala has been so hot and so dry and dusty, but with your coming, you brought us the good luck and came with rain and a change in weather. So let's clap for our visitors, my fellow Ugandan prosecutors. To us in Uganda, all those are blessings. A visitor who comes with rain will always be remembered forever, because we mark our seasons depending on the weather. So, and the dress code for the dinner will be casual smart, and be prepared to dance, to mingle and mix and relax after 4 days, these 3 days of intensive work. Thank you very much. Secretariat, please come and take us through the resolutions.
Distinguished ladies and gentlemen, we request for 5 minutes. We wait for Justice Sapodo to come. We can take a bathroom break for 5 minutes. Our host has joined us. Ladies and gentlemen, I've been given the distinct honor to take you all through the draft resolutions. Most of you have been given copies of it, but the same has also been...
There's a microphone there. No, this one. You can use this. It's on.
But the same is also projected on the screen. I'll take you all through the resolution, starting with the top. It'll be noticed that now we are referring to ourselves as Eastern Africa Association of Prosecutors, the 10th Annual General Meeting and Conference of the East Africa Association of Prosecutors. I'm afraid that needs to change. At the top. No, not there. At the top. Yes. Okay. So there is a 10th Annual General Meeting and Conference of the Eastern Africa Association of Prosecutors in Kampala, Uganda. Declaration 2023. The first sentence is, whereas this East Africa Association of Prosecutors, being a body of prosecutors from across Eastern Africa, met in Kampala, Uganda, during the 10th Annual General Meeting and Conference from 26 February 2023 to 2nd March 2023. This is because this is how we began. And whereas the theme of the conference is transboundary crime, practical approaches to protecting women and children, given that we as prosecutors from Eastern Africa recognize the need to improve collaboration, cooperation, communication, trust, mutual legal assistance, and extradition among the prosecuting authorities and agencies, aware of the effectiveness of coming together from different prosecution authorities in the Eastern African region to develop a common approach towards combating common challenges of transnational organized crime, affirm our commitment to work together under the umbrella of the Eastern Africa Association of Prosecutors from the 28th February 2023 in efforts to expand the scope of cooperation among prosecution authorities beyond the East African region. Further aware of the need to address the protection of women and children, recognizing the challenge of transboundary crime affecting women and children, we state as follows. Our concerted efforts will be applied to to address ritual killings of children and have determined to take steps towards protecting children from these harmful practices. In responding to the threat posed by proceeds of crime, to develop joint strategies and agreements to trace and confiscate proceeds of crime to deter criminal organized groups from creating safe havens in the region. Recognizing the need for capacity building among the prosecution authorities in the region, we'll establish regional institutes for prosecution training to offer professional courses to effectively address transnational organized crime. Further, we recognize that transboundary crime disproportionately affects women and children, exploiting their socioeconomic vulnerability. Further, responding to the need of witness and victim protection in cases of gender-based violence, trafficking in persons, and child exploitation and abuse. In responding to these threats, EAP recognizes the need to develop mechanisms aimed at tackling transboundary crime and protecting women and children. Therefore, we as members of the Eastern Africa Association of Prosecutors resolve to promote, facilitate, and support cooperation and collaboration between prosecution authorities within the EAP towards enhanced prosecution of transboundary crimes, increase the scope of membership of the EAP to include countries within the larger Eastern Africa, which will include countries in the Central and Southern Africa hemisphere and Indian Oceanic countries in the region, and admit into its membership the Republic of Sudan, the Republic of Somalia, and the Republic of Seychelles, having ratified the expression of interest to join the EAP. Prioritize adoption of gender-sensitive initiatives within the criminal justice sector to strengthen protection of women and children. Increase efforts towards tackling crimes that specifically target children, such as child sacrifice and online child sexual exploitation. Identify standards and best practices in witness protection and victim facilitation, and develop guidelines on the role of prosecution services in witness and victim facilitation. Encourage states, in accordance with their domestic legal principles, to remove barriers to regional cooperation and collaboration, including simplifying legal processes and by processing requests for assistance without any undue delay. Promote avenues for informal sharing of information and joint capacity building to increase synergy between member states. Enhance asset recovery efforts by member states by encouraging the development of strong legislation and robust asset recovery mechanism. Promote the development and implementation of technological tools to enhance the prosecution, investigation, prosecution, and adjudication of transboundary crime. And we therefore adopt the Kampala, Uganda Declaration during the 10th Annual General Meeting and Conference of the Eastern Africa Association of Prosecutors held in Kampala, Uganda, 28th February of 2023. We are ready for comments. We can also go in the way of proposing and seconding, or comments, even if it is a positive one. Positive comments can also be said, please.
I'm sorry, I'm going to try to speak in English. In our declaration, we have sometimes the expression East Africa and sometimes Eastern Africa. So I think somewhere we need to have a paragraph saying why we moved from East Africa to Eastern Africa. Maybe before we use the expression Eastern Africa. In other words, in the title, we're not supposed to have the Eastern Africa Association. We'll talk about Eastern Africa Association later, after we explain how we came to that new name. I don't know if I make myself clear. Thank you.
DRC. Je ne vois pas l'incise de la sincérité dans la coopération judiciaire. La sincérité. La sincérité dans la coopération judiciaire.
DRC, maybe you can propose where we can put the paragraph?
Give me 1 minute to...
Mozambique, would that paragraph that explains aware and affirm answer your question?
Yes, it answers my question, but the problem is, in the title you suggested to change right up there. There. You already put Eastern Africa before you explain that we moved from East to... Am I clear? Yes. Because when you started this meeting, the organization was Eastern Africa. Later, with the approval of the Constitution is when the organization changed. So I think it's better to make it clear in our declaration. Thank you.
Burundi?
Oui, merci. Parmi les adoptions qui ont été faites, il y a une qui accorde le statut d'observateur au chairperson of African Judge Dialogue Forum. À travers ce qui a été lu, ça n'apparaît pas clairement. Comme on a bien mentionné qu'on a accepté dans l'association La République du Sudan, de Somalie et de Seychelles, il serait mieux aussi de faire figurer dans le texte que le chairperson of African Judge Dialogue Forum a été admis comme observateur de l'association. Merci.
Okay, Secretariat at the back, kindly make those changes. Okay, members, Somalia.
I think at some point in our discussions we talked about East African Training Academy, I think proposed by the Minister of Justice and Constitutional Affairs of Uganda. Have we abandoned that idea, or do we want to include it, or how do we proceed with that? Thank you.
Members, I'd like to go through that issue of the training institutes. Secretariat?
Yeah, I see it now.
Okay.
Yeah.
So we are left with the one for the Judges Forum. Kindly include it after. Okay. And the next one is.
Have we addressed Mozambique's concern?
No, we have not. That's the next thing we need to do.
Okay. Can I propose before we move to another point?
Yes, sir.
Maybe then we can refine the language. If we say, whereas the East African Association of Prosecutors, being a body of prosecutors from across Eastern Africa, met in Kampala, Uganda, during the 10th Annual General Meeting and Conference from 26 February to 2nd March, the AGM ratified the expansion of its membership Uganda says to include. Then now we can put the additional countries. Mozambique. I'm just saying in no particular. DRC. Mozambique. Okay. DRC. No, it's everyone. Yeah. Isn't it? Yeah, because this one is still. Oh, where's this? So is it the Eastern? Because my paper here reads East Africa. Whereas the East Africa.
Yes.
Yeah.
At the top it reads East Africa at the top. It should read East.
I think that's the point. The first sentence there.
We are saying
it should be East, not Eastern.
Whereas the East Africa Association of Prosecutors.
Yeah.
Yeah, because that's where we started.
No. Actually, I think they're right. It's Eastern.
So I think further, if you take it up there, what we have reads Eastern. I don't know whether it should be Eastern. I'm referring to the caption at the top, right at the top. Whether it should be Eastern or it should be East. Right at the top where the logo is. There.
Okay. Then it's okay. Then there you change East Africa. This paper of mine reads East Africa. So change up there as Eastern African Association. No, down. The next paragraph. 10th Annual General Meeting and Conference. And Conference of the East Africa.
Yes.
Change it to Eastern Africa. Then we should explain. That's what we are saying. If that is the case, we should explain.
So we begin first as East, then we transition to Eastern.
So
but remember also the resolution is by Eastern, because by the time we are issuing it, we are already Eastern.
Yes.
So then do we start as how do we start? Where as the East African Association or where as the Eastern Africa? East. Yeah. So then that's why I was explaining there. The annual general meeting ratified the expansion of its membership to include, isn't it? To include Malawi, DRC, Mozambique.
Alphabetically, please. DRC.
Democratic Republic of. They will put the full one.
Alphabetically.
Mozambique, Zambia, Somalia, Ethiopia, is there anyone we've left? Seychelles, and Sudan?
Yes.
And Sudan.
No, it's not.
The Eastern.
Yeah. And then somewhere down there, then you explain that we are now the Eastern African, isn't it? Is that okay, Mozambique?
Yes, it's really better, but still, I'm not sure that the big title up there must be Eastern Africa. And also, in the second paragraph, where we say, being a body of prosecutors from across Eastern Africa. Yes. Thank you.
And then, so up there we have it as East Africa Association.
In my understanding, up there we're supposed to have East Africa, because when we started this meeting, it was invited for East Africa. But during the meeting, we agreed to move further. So I think with the first paragraph, the way we explained now, we can now have Eastern Africa in our document. But before that, we're supposed to have East Africa until we explain how we moved from East Africa to Eastern Africa. Thank you.
Okay, so we will change the logo up there. It's the logo that we will change. We will change it to the East Africa logo.
No, the logo is still the same.
I'm saying that
just instead of Eastern
Africa
East
Association of Prosecutors up there.
Fine. Let it reflect as East Africa. That's what we are saying.
South Sudan?
No, the logo should be there, Eastern Africa, because we adopt it today and it will be the logo of, it cannot be changed again. No, the logo down, yes. Go down, yes. Eastern Africa Association of Prosecutors is there in place. You cannot say that East Africa Association of Prosecutors.
Yes.
It will be in its place.
Yes, we can.
Because if you change it, you need another meeting to come and change this again.
And, no?
Can we go to the other content?
No, okay, let me just try and explain what I think what he was trying to say. There is a difference between the logo of Eastern Africa Association and East Africa. And the difference is in the map of Africa. So if we are going to put East Africa, it will reflect East Africa, less states around the... But that one, the Secretariat can do it. Are we in agreement that it should read East Africa and not Eastern Africa? Let's agree on that.
Merci, Monsieur le Président. Moi, je soutiens l'idée que l'entête qui est affichée soit maintenue comme Eastern African Association of Prosecutors, parce que la déclaration qui est en train d'être confectionnée maintenant est en train d'être faite au nom de Eastern African Association of Prosecutors. Bien qu'au courant de nos travaux, nous avons quitté une situation pour en créer une autre. Donc, ce que nous avons déjà créé doit apparaître dans la déclaration finale. Et ce qui a été créé, c'est Eastern African Association of Prosecutors from now. Thank you.
Kenya?
Can you take us to the paragraph that says whereas the East African Association? So maybe after Sudan, we can say to become the Eastern African Association of Prosecutors. Somebody can refine that. Is that okay? Are we in agreement? So we can proceed to the next point.
Okay, then kindly go up slowly. Paragraph 3.
No, excuse me.
Paragraph 4. Is there any issue with paragraph 4? Paragraph 5.
Yes, Sindano. Is it DRC? Sindano.
Est-ce que vous pouvez encore remonter là? Parce qu'il faut restaurer la vérité. Si vous voulez remonter, il faut restaurer la vérité historique. Non, premier paragraphe. OK. La République démocratique du Congo, les Malawi, Mozambique, Zambie n'ont pas été admis le même jour que la Somalie et les Seychelles. Non, non. Nous devons garder la vérité historique. Alors, dans ces cas-là, on peut dire d'abord, il y avait ces pays-là, et ensuite, les autres qu'on vient d'admettre aujourd'hui, les Seychelles, Somalie et le Soudan. Parce que les autres étaient déjà des membres. Ils étaient déjà des membres il y a plus d'une année aujourd'hui. On ne peut pas les considérer qu'ils sont admis aujourd'hui au même titre que ceux qui viennent d'être admis aujourd'hui. Seychelles, Soudan et Somalie, c'est aujourd'hui qu'ils viennent d'être admis. Alors, nous devons restaurer la vérité historique sur ce point. Et je vous envoie aussi pour les recommandations au 7e point, parce que vous m'aviez demandé de chercher la reformulation. Pour les recommandations. 7e point. Encourage states in accordance with their domestic legal principles to remove barriers to regional cooperation and collaboration, including simplifying legal processes and by processing requests for assistance without any undue delay. I would like to input this before, without, by processing requests for assistance with sincerity, without any undue delay.
DRC, okay. Maybe you can confirm if that's already what you wanted.
Okay. Repeat. Recommendation number 7. Encourage states in accordance with their domestic legal principles to remove barriers to regional cooperation and collaboration, including simplifying legal processes and by processing requests for assistance with sincerity, without any undue delay. Sincerity. We need a sincere cooperation. Sincere cooperation.
Well noted, sir. Will we go back to the top? Paragraph 1. How
we had the two waves of admission. The first wave concerns DRC, Malawi, Mozambique, Ethiopia, Zambia. That is alphabetically. But the second wave concerns states admitted today in this conference during the today general meeting.
Okay, I could propose, then it means that the language has to change from where we're saying the beginning. If
No,
that is
Mr. Muranga, I think it's okay. What he's saying, he just wants it in order of those who joined. So Democratic Republic of Congo, Ethiopia, Malawi, Mozambique, Zambia joined before Seychelles, Somalia, and Sudan. So we are okay now. Is that okay, Shindano? Shindano, iko sawa?
Tunakubali, President.
Sawa, we move to the next point.
Okay. Ladies and gentlemen, paragraph 2, paragraph 3, paragraph 4, paragraph 5, paragraph 6, paragraph 7, 8, 9, 10. It's too fast. 10, 11, 12. Go up. Therefore, we as members of the Eastern Africa Association of Prosecutors resolve to point 1, point 2.
Yes, there's a paragraph where you enumerate, it's up there, before whereas, where you enumerate the membership. Go down. Yes, when you talk about there, affirm. So when you talk about increasing membership, something was mentioned about including individual membership of prosecutors. I have not seen that come out, so I was wondering if it would be appropriate to include that in the resolution.
Can we include that? Can we add it?
We stand guided, but that is a futuristic proposal. But if you advise, then we can be able to include it.
I think we include it.
And to admit membership, yes, to admit the membership of will we say in prosecutors, or will it be prosecutors? Individual membership of prosecutors of the national prosecution authorities.
Yes.
Of the national prosecution authorities.
Excuse me, sir. Excuse me.
Sorry?
Yes.
Me. Sorry. No, I understand the proposal, but I'm not sure that we discussed that. I think it's something that the incoming president, in his few remarks, highlighted as something that he is bringing in. So I don't know if it's supposed to be part of this declaration right now. I'm not sure. Thank you.
I think admitting the membership of individual prosecutors was the plan of the upcoming president, and I think if we take it, it will be very good for the association. Thank you.
Could I suggest?
Je voudrais un peu d'explication par rapport à l'adhésion individuelle des procureurs. Est-ce que ça signifie que ce sont les procureurs des pays qui ne sont pas membres de l'Eastern African Association of Prosecutors? Est-ce que un procureur d'un pays membre peut demander une adhésion individuelle alors que son pays est déjà membre? Il faut bien clarifier. Ou ce sont les procureurs des pays qui ne sont pas encore membres, au moment où leurs pays n'ont pas encore demandé l'adhésion? Je voudrais un peu d'explication. Merci.
Okay, individual membership means our prosecutors of the member states, not from outside. So apart from the country, your individual prosecutors who work for you can also join as individual for various purposes. Maybe we need to refine and define what rights they have and all that. And as Mozambique said, we can remove it for now, but in the next meeting, we table a proposal of how they can join and what rights they have. In other associations, you have the countries that head the association, but you also have their prosecutors as members for purposes of, one, raising funds, and also awareness of the association and what the association stands for.
The paragraph remains as it were. Kindly go down. Did we include the paragraph on the Forum for Judges? Okay, that's paragraph 3. Burundi, is that okay? Is it satisfactory? Okay. Paragraph 4. Yes, sir.
If you can go a little bit back in the preamble, back, there's a paragraph where you listed a number of offenses or crimes to which children and women are prone to. I think terrorism is missing, so it should be included there.
Pardon, repeat again.
There's a paragraph, I think, before the recognizing, if you go back. A number of our offenses have been listed to which children and women are prone to as victims, but terrorism is missing. It starts with the father responding to, if I'm not mistaken. Yeah, there.
Is that satisfactory?
Yeah.
Any other comments? Can we go back to the numbers at the bottom? Number 1, number 2. Mozambique?
Again, I have a question. I don't know if I understand properly. When I read number 2, and number 3, I think they are repeating or they're covered with our new written of the very first paragraph, where we explain the extension of the EAP to be Eastern Africa. I don't know. But it seems like you are repeating ourselves there.
Yes.
Thank you.
So do we retain it for emphasis, or you think it is sufficient if we have the paragraph as it were in the beginning?
If you put it conscious that is to emphasize, it's okay. We can leave it the way it is.
Any other comment?
I think for emphasis, we should retain it.
Agreed.
On that, if it's for emphasize, you can maintain the way it is. But in that case, there are some countries that are not repeated there, while some are there. So how do you explain that? Because the Somalia and Seychelles are from today, or what exactly?
I think the previous ones, DRC, Malawi, Ethiopia, were admitted previously. Today is just ratification. But today, Somalia and Seychelles are now admitted.
Is that clarification better? Maybe you can write the annual general meeting in full. Number 4. Yes, sir, Burundi.
Come back, please.
Up.
But no. No, where you say that the association which was granted the members the status of observer. Okay. The chairperson of the Africa Judge Dialogue Forum, having ratified their expression of interest to join, are they at the same level? One wants to be a member of East African Association of Prosecutors, and another one wants a status of observer. So you have to distinguish the two.
That's in order. Thank you, sir, for that. Number 4. Number 5. Number 6. Number 7. Number 8. Number 9.
Mr. Gitonga, if you will allow me, although UNODC is not a member of the East Africa Association of Prosecution, we are a partner of the EAP, so if you will allow me to do a minor suggestion just to elaborate further on resolution number 8. As you have decided today to increase the membership of the EAAP, and as this platform grows bigger and bigger, involving more countries and also additional prosecutors from all across Eastern Africa, you will have a greater task ahead of you, but also more legal minds to tackle organized crime. So in an effort to promote targeted regional cooperation, which is mentioned here, as well as information sharing of intelligence, whether formally or informally, perhaps also for the EAP Secretariat to further consider later on whether you could establish targeted technical working groups or subcommittees or smaller forums on crime-specific committees, specifically on whether it's human trafficking or advancements in technology, to utilize the expertise that you have within this forum today. You have experts on technology, experts on money laundering, experts on tackling human trafficking, and to have a more targeted subcommittees, perhaps also that would enhance capacity building further and promote targeted or increased prosecutions of the different organized crime. That is a suggestion, and thank you very much.
So perhaps it's being amended. You could give the suggestion on how to word it.
Including but not limited to, it could be crime-specific technical working groups.
To develop thematic working groups.
Mm-hmm. Thematic working groups. On the different crimes, or technical working groups on different organized crime. That's the case. And then it's up to the EAP to consider whether they want to start with a pilot technical working group to see if that is successful, and then to incorporate further subcommittees. Perhaps you can consider human trafficking, given the large number of victims and numbers of the profit. Thank you.
Will it be in order to also add focal points, which we've already done as part of our process? So thematic technical working groups on thematic transnational organ crimes and focal points. Okay, that's in order. Mr. DPP, Tanzania?
It is fine, because even our constitution allowed that. I think there's no problem putting it in there. Thank you.
Okay. Paragraph 9. Paragraph 10. Distinguished ladies and gentlemen, we are done.
Thank you very much, members. So this is the Kampala resolutions. And that marks the end of our 10th conference and annual general meeting. Thank you very much for your valuable contributions, for your comments. As we have come to the end of our conference, may I take this opportunity to wish you safe journey for those who will be traveling out of Uganda. And the next AGM and conference, the venue and the date will be communicated by the Secretariat. Unless there is an announcement from the Secretariat. Maybe members, before we with this part. We, in our 10th AGM, we had an election, so we have new leaders to our associations. Maybe I ask the Secretariat at least to inform the members who were not present during the election process.
Distinguished ladies and gentlemen, I wish to announce the new officials of the Eastern Africa Association of Prosecutors. The president of the Eastern Africa Association of Prosecutors is Honorable Mr. Nurdin M. Haji. Followed by the Vice President of the Eastern African Association of Prosecutors from Rwanda, Mr. Amable Havugiriyama. I hope I don't know if I pronounce it okay. And the other Vice President is Honorable Mr. Famin Mvonde Mambu from DRC. The Secretary General is Lady Justice Jane Frances Abodo. The Treasurer is Honorable Mr. Sylvester M. Mwakitalu. And the General Counsel is from Mozambique, Dr. Beatrice Butili. Thank you very much.
So members, thank you very much. Good evening.
Some announcements. Members, those of you who have not yet handed in your boarding passes, please don't forget to hand them over to Vicky Nabisenke. Please, Vicky, stand up so that they see you. So please, members, don't forget. The Secretariat also has packages for each of the delegations. They're at the Secretariat desk. So each delegation should send one person to pick those packs at the reception as we leave this room. And then lastly, there is someone who lost his car keys. Please don't get stranded. I'm going to leave them at the hotel reception as I exit. Thank you so much.